we need an interpreter?
Yes, sir.
Robert, are you okay? All right.
Good morning.
I'm going to ask, would you like to go first then?
¿Quién va a hablar primero?
Identify yourself.
Yo solo voy a hablar.
She's just going
Yo
to
solo
talk.
voy a
He's just here.
Oh, okay, got it.
Y va a
Sorry.
hablar de este
No,
texto,
Luis.
¿cierto?
know about any of the history, is that right?
Whenever I was
Hombre,
Katie Torres.
Okay, and can you spell it for the record, Robert?
Puede leerse K con K, ¿cierto?
K,
K-A-T-I-Y, ¿cierto?
K-E-T-T-Y.
K-E-T-T. K-E-T-T-Y. ¿Y Torres con S o?
Con S.
Torres, T-O-R-R-E-S.
Okay. And present with her is her husband and his name?
¿Y con ella es su nombre, señor?
Tu nombre.
¿Cómo?
Tu nombre.
Clever Candelario.
¿Cómo?
Clever Candelario.
Clever Candelario.
Él no
Clever.
escucha bien. Él no escucha bien. Tiene un problema de audición.
This gentleman has a hearing problem.
Okay, that's fine.
Ok.
Okay, Clever con
¿Qué?
C.
Con K.
Con K.
K-L-E-B-R.
K-L-E-V-E-R. K-L-E-V-E-R. ¿Y el apellido?
Candelario, con C.
Candelario. Same as the document.
You're good? All right, good.
Okay, bien, señor. Frase por frase.
Excelentísimos jueces de la Corte,
Honorable Judge of the Court.
con el corazón partido en 1000 pedazos,
With my heart ripped apart in 1,000 pieces,
pero desde el amor y sostenida por Dios,
but speaking from love and maintained by God,
estoy aquí para decirle al mundo
I am here to tell the world
que mi hija salió de un hogar
that my daughter came from a home
donde se creó una relación de humanismo,
where there was relations of humanism,
valores,
values,
creencias,
beliefs,
afectos,
emotions,
calidez,
warmth,
donde lo más importante era la familia.
where the most important thing was the family.
Cristel creció y se formó
Crystal grew up and was educated
en un ambiente sano junto a sus padres.
in a healthy environment together with her parents,
Protegida y amada.
protected and loved.
Realizó sus estudios en nuestro país natal, Ecuador.
She studied and was educated in our native country of Ecuador,
Escogiendo la misma profesión de su abuelo y sus padres.
and she chose the same profession as her fathers and her grandfather,
La docencia.
teaching.
Sus años de edad adulta fueron marcados
Her years as an adult were marked by
por problemas de salud física y sentimentales.
both physical and emotional problems
Que no siempre terminaron de la mejor manera.
that didn't always end up in the best way.
Su salud emocional se vio afectada en más de una ocasión.
Her emotional health was affected on more than one occasion.
Pero entre trabajo, responsabilidades y el día a día,
But between her work, her other responsibilities, and her day-to-day life,
en un ir y venir, no logró priorizar la importancia de un tratamiento continuo.
in the middle of all that, she never ended up prioritizing or appreciating the importance of continued treatment.
Por lo que la depresión y la ansiedad y el trastorno de neurosis de conversión fueron ganando terreno en su vida.
And because of all that, her depression, anxiety, her conversion neurosis disorder, all ended up consuming her.
razón por la que siempre sufría desmayos y pérdida del conocimiento.
And as a result of this, she suffered fainting spells and also loss of consciousness.
Con esto no quiero victimizar ni justificar a nadie,
In saying this, I don't want to victimize or justify anyone,
solo mirar el yo interior de quien hoy está aquí sentada y siendo juzgada.
I only want to give a glimpse of the interior person, the ego of someone who is seated here and who is being judged.
Señores, las enfermedades de salud mental no se reflejan en el rostro.
Ladies and gentlemen, the sickness, a mental health illness is not reflected
Ni
in
en una-
someone's face,
Ni en una foto.
and also not in a picture, in a photo.
Nacen y se quedan en el alma
It arises and remains in the soul.
Solo un tratamiento a tiempo y eficaz con ayuda de terapistas y médicos ayudan a mejorarlo.
And only a timely and effective treatment by therapists and doctors can help to improve those conditions.
Mi hija no tenía calidad de vida
My daughter did not have a good quality of life
porque ella no podía pausar el trabajo.
because she couldn't stop working.
Nunca nadie imaginó que este sufrimiento terminaría en tragedia.
No one ever imagined that this suffering would culminate in a tragedy.
Y hoy aquí quiero decirle a Yailin
And here I'm.
que eres
here,
nuestro
I-
ángel, Yailin.
I want to say here before Jaylene, our angel,
Tu recuerdo vive en nosotros.
that your memory lives within us.
Siempre te amaremos.
We will always love you.
Te acuné en mis brazos.
I held you in my arms.
Tus abuelos nunca te olvidarán.
Your grandparents will never forget you.
Perdóname, bebé,
Forgive me
por vivir la oscuridad del conocimiento
for being in the dark
que me imposibilitó ver la luz y poder ayudar a
and
tu
for being
madre.
in the darkness that prevented me from seeing the light to see what was going on with your mother.
Hija querida, cuánto te amo.
My beloved daughter, I love you so much.
Lamento y me arrepiento
I lament and I am
Por no
so
haber-
sorry
por no haber detectado lo que estabas viviendo.
for not having detected what you were going through.
No leí tu corazón.
I could not see what was in your heart.
No me percaté del caos
I didn't notice the chaos
por el que estabas atravesando.
that you were going through.
Lamento ahora, hija de mi vida, causarte este dolor.
I lament my darling daughter that I caused you this pain.
Señores de esta sala,
Your Honor,
pido misericordia,
I ask for mercy.
clemencia y compasión
I ask for mercy, for clemency, and for compassion
para un ser humano
for a human being
que ha librado una dura batalla en su vida.
that has waged a very difficult battle in her life.
Y ruego no satanizarla
And I beg that you not
ni señalarla.
I beg that you not demonize her and point the finger at her.
¿Quién en esta vida no ha pecado contra Dios?
Who in this life has not sinned against God?
Que levanten la mano quienes no lo han hecho.
Anyone who hasn't, let them raise their hand.
Pero como creemos en un Dios de amor y de bondad
But since we believe in a
More time.
y de,
in a God of love and of goodness,
en un
the time of autopsy and after the autopsy, we met with the detectives.
Excuse me, Dr. Cannon, I know you're
Yeah.
probably having difficulty hearing, but when an objection is made, I'm going to need you to stop talking so I can make a ruling on the objection. And
Okay.
attorneys need to use your microphones. All right, you may continue, Dr. Cannon.
It's at the time of autopsy and after.
Who was present with you when you performed the autopsy?
It's from the law enforcement. I believe it's Detective Saints, but I could be others. I can't remember.
It's not specifically noted who was there?
No, ma'am, no.
When you looked at Mercedes, when you looked at her, you didn't have any initial first impressions?
Object to leading.
That'll be overruled. You can answer.
Yes, yes. First impression is yes. This child suffered trauma.
How much trauma?
Well, it's extensive from top to bottom, all over the body.
Was Dr. Molina present when you were doing this?
Object
No,
to honor.
I'm
All right,
sorry,
that'll be overruled. You can
no,
answer.
ma'am, no,
she was not present.
no.
Okay. When you do an autopsy, do you have anybody helping you?
No, it's just me.
And possibly Detective Size?
Yes, if they come for observation, we allow them because they're the lead law enforcement agency.
There was evidence of medical intervention. Your notes indicate defibrillator pads are present on the chest wall.
Yes, ma'am.
Needle puncture is present just above the right knee.
Correct.
And intro,
Osseous.
thank you.
Yes.
Needle is inserted in the left shin.
Yes.
And that indicated that somebody tried to save the child?
Yeah, it's from the hospital. It's pretty routine to see this.
All right, now, the first thing note I have here is that the head. What do you recall about Mercedes' head?
Yes, I listed on each section because the injuries are pretty all over. So the head had a lot of abrasions or scrapes, and on the front, back, cheek, and also the back had a small a tear of the skin as well
Where was that, sir?
in the back of the head.
The top? What part
In
of
the
the back?
In the back.
Plain old center back, or,
Yes.
and what do you think that was from? Could you tell?
It's a blunt trauma.
Blunt trauma?
Yes, ma'am.
Would you have considered that a cause of death?
No, that's not alone as a cause of death.
But was it significant enough that potentially it could have been a cause of death?
Like I said, we don't infer just on one small tear. It's the overall picture which matters.
Yes. So that tear wasn't enough to give you a distinct impression at that point? Is that
No,
fair to
not
say?
at this point. No.
You talked about Mercedes' lip.
Yeah.
Broad 5 by 3 centimeter area of erosion with overlying superficial layer of thin tan granulation tissue. What does that mean, granulation tissue?
It's
I'm sorry, Your Honor, I'm going to object to her reading from a document that's not in evidence.
All right, that'll be overruled.
yeah, what it means is it's a tissue trying to heal.
What part of the face was it?
It's on the inner side of the lip.
Inside her lip.
Yes.
Could you ascertain what the source of that injury was?
No, we can't tell.
Like a child biting the inner side? inside of the
No,
mouth?
it's not biting. It could be any kind of trauma on top of the lip.
Did you notice some missing teeth?
Yes, I did.
Do you remember how many?
A few.
Was it unusual for a child of this age to have missing teeth?
I mean, one is we can happen if they fall, but quite a few with overlying trauma with different stages of healing is not common. It indicates there is some repeated trauma.
For how long a period?
It's probably days.
Days?
Yes, ma'am.
These were her baby teeth, as we lay people call them. Was
Yes,
that,
these are. Yes, that's right.
forgive me with these words, but present on the proximal mid-occipital scalp head are two contusions measuring 2 by 3 centimeters. What is that?
It's on the back of the head are contusions or bruise.
Were these recent?
They appear recent. Yes.
And when we say recent, are you talking in terms of hours, days?
I would say days.
Have you, at this point in time, begun to formulate a cause of death in your mind?
No, because these are complicated case, and we need to gather all the information.
Why was it complicated?
Because when I also need to look inside the body, not just outside. And
That-
inside the head, I did not see any obvious immediate cause of death.
So it was not, is it fair to say it was not the focus of your examination, her head?
Head is the main part of the examination, but I also look at other cavities like chest and abdomen.
Abdomen. You talk about a cluster of 3 contusions measuring 1 to 2 centimeters present on the lower left abdomen above the inguinal region. Was this done with, can you ascertain what caused these injuries?
It's just some kind of blunt trauma, and I can't really tell exact mechanism how it happened, but there is some trauma.
Thank you. You talk about her fingers being swollen. What is that from? Was there an obvious injury there, or? why
No,
were-
what it is it's an injury, but the tissue is reacting to the hand, and that it's swelling is common in injury.
Even post-mortem?
Well, it's around the time of death, so yeah, I can still observe it.
But it was observable, that's that.
Yes.
And her arms had several different kinds of contusions, is that correct?
Yes, that's right.
There was no evidence of sexual assault, am I correct?
I did a complete examination and collected trace evidence. Um, I'm not sure if it was submitted, but based on my exam, I examined the inside of the anal canal, vaginal canal. I did not see any tears or trauma.
Thank you. At any point, did you examine her throat?
Yes, inside, yes.
Did you see anything there?
But no, I could not see anything.
There was an allegation against the mother in her indictment that she had shoved a utensil down her throat. Did you observe any injuries from that?
I mean, not at the time of death, no, ma'am. No, there was no evidence of trauma.
Inside her throat?
That's right.
The child, did you know the child had asthma? Was that obvious to you?
I looked for signs, but I did not see anything
You did not.
obvious in the body. Nothing in the body.
Typically, if a person came before you and had asthma, is that something you would notice right off the bat, or you'd have to
No.
look for?
No, because asthma, remember, they don't come to medical examiner. It's a treatable condition. And we have signs of asthmatic attack when they go to hospital. Typically, they tell us what happened. And we kind of already know what to look for. In this case, that was not obvious.
But have you seen deaths from a bad reaction to asthma?
Oh, yes, yeah.
You did a full dissection of Mercedes' back, is that correct?
I examined, yes.
It says a full dissection of the back.
Yes, yes, ma'am.
Now, I've seen autopsies on television, forgive my lack of knowledge. Do you turn the child over to examine the back or?
Correct. Yes, we have to.
Okay, and you cut the back as well?
Yes, yes.
Specifically, what did you observe that could have caused her death?
Well, I mean, like I said, all the injuries in the back, like around the buttocks, there were blood seeping into the deep tissues, which indicates the injuries I observed on the top went a little bit to the bottom. But again, these are only skin and soft tissue injuries. And that is not the immediate cause of death, but it can contribute to the death based on the severity and the distribution in a small child.
There were, I'm reviewing your report, it said there was no evidence of skull fractures.
That's right.
Hyoid bone, where is that?
Hyoid bone is a U-shaped bone, especially in a child. It's in the neck, and it's very flexible, very soft and thin in a child.
And you said that the hyoid and larynx are intact.
Yes,
The hyoid bone was dissected and there was no evidence of trauma.
correct.
The airway is patent and unremarkable.
Yes.
Did you notice subsequent, or rather, excuse me, before this, is it fair to say that you did not see the ER charge nurse's report?
We look into it, but we don't look into that much detail because I have the body in front, and if necessary, I will go back and read.
If the charge nurse had said that he removed food from the child's windpipe area, would that have affected anything that you looked at?
Well, the thing is, we need to know, is it really significant? Because there is chance of terminal aspiration, meaning if somebody is in the process of dying, and the breathing kind of is not normal, and sometimes food can get aspirated. So it's we have seen that before. That's not the sole cause of death.
But it could be.
It only if it is significant, like a big chunk of meat, and then that needs to have evidence, like somebody saw somebody choking and went blue and then suddenly died, not slowly deteriorating. So it's a different scenario.
When you observed this autopsy of Mercedes, could you determine whether it was a sudden death or
It did not seem to be, based on the scenario presented, it seems like the patient or the child was deteriorating for a while.
stomach and intestines? Says the stomach is distended with large amounts of partially digested food material, which consists of partially digested fragments of what appears to be thin, white, noodle-like material along with soft white material. Is that something very unusual or not unusual?
Not unusual, it just depends on what they ate.
Were you able to determine what the actual food was?
No,
Just noodle-like.
yes.
Thank you. You tested for COVID,
Yes.
and what was that?
Just maybe at the time, just to rule out if anything else was going on.
Thank you. Now, I noticed in your microscopic examination of the lungs that the alveoli were slightly dilated and there were scattered minute elongated foreign material in the alveoli under polarized light. Could that have been the noodles?
No, I think it's probably over time, something in the food, what she ate could have been there.
There's a whopper of a word here, EOSINOPHILIC. Would you pronounce that?
Yeah, eosinophilic.
Yes, eosinophilic infiltration. No evidence of that?
Yes, what it is I'm describing, those are signs of asthma. And I didn't see any acute signs of asthma attack. So I'm saying a negative finding.
All right. Thank you. Mucus, well, there's also no mucus plugs or thickened bronchial muscles, correct?
Yes, so again, those are also signs of asthma.
It said that there was a decalcified medial end of the clavicle. What does that mean?
What it is I took a small segment of collarbone, and then you can't cut a bone, so you had to thin it out and then look under the microscope just to make sure that there is no problems with the bones. It's not a brittle bones or anything which can fracture. So documenting a normal finding, just to be thorough.
There was a comment here that healing abrasion of the skin, crater-like ulceration of dermis. What does that mean?
I took a section of uh, the trauma or the scrape, which looked like old, and I want to confirm it, and it confirmed that it's an old skin lesion.
Again, it couldn't be ascertained the cause.
Well, it's trauma.
The tubules, where are they?
That's in the kidney.
There's evidence of necrosis in the kidney.
The kidney under microscope, the tubules are the small tubes which collect the transport the urine, and those under the microscope showed evidence of damage, meaning the kidney is failing.
It failed prior
It's
to
just,
or,
it's not functioning.
but was this prior to her death or
This is around the time of death.
around the time? Is that unusual?
Yes, it should not be there.
How would it get there? If you
I'm
know.
sorry.
Repeat your question.
How would that get there?
Uh, So the damage is caused in this condition by the products of the muscle being broken down by repeated trauma, and kidney is a filtering organ, so it's can't handle the load and shutting down.
Okay, we're almost through. Excuse me. The findings, multiple blunt force injuries of the body and their extent. Evidence of rhabdomyolysis. Would you explain rhabdomyolysis, please?
Yes, yeah. So the word rhabdo means muscle in Latin, and lysis is breakdown. So what's happening is due to the repeated trauma to the body, um, whatever injuries you see on the skin is affecting the muscles underneath, and the muscles over time break down, and the small molecules of the muscle gets to the bloodstream and to the kidney, and then eventually everything shuts down.
Are you able to quantify?
No,
You're not able to quantify the
No.
degree to which they've broken down?
no, I can't quantify.
Is there a test that would quantify it?
No, I mean, we are even lucky to detect this stain in the kidney, which detected it. So that's the best we can do.
But there's no definitive determination about this, is there?
I mean, that is what it is, and then we know that based on the circumstances of the death, the extensive injuries of the death on the body, that it's resulted of trauma.
You said the circumstances of the death. When
Yes.
you performed this, were you aware of circumstances of this death?
After the autopsy, yes, yes.
At this point, when you wrote these forms after the autopsy, not
Yes.
during?
Yes, we have to wait for all the evidence, talk with the investigating police agency, and then I have to come to a conclusion after.
People can survive rhabdo. Can I use the shortened term rhabdo? They can.
Yes,
they
if
can-
you are made it to hospital in the right time, not at the end stage, yes.
The testimony indicates that she was brought to the hospital with no life signs.
I think she was pretty much collapsed.
Now, which muscle was it that caused her death?
Well, no.
What?
Well, we can say which one. It's just general all over the body.
Well, you have muscles in your legs. Was it the muscles in her legs that caused her death?
Any muscle.
Any muscle could cause her death?
No, here in this particular case, the breakdown is resultant of muscles,
I'm sorry, so the breakdown of what?
of the muscle, any part of the body.
So if just your leg muscles broke down, that would kill you?
No, not just alone, the extent of the injury and over a period of time, it just adds up.
But at some point, there's this specific muscle that'll cause the death, right?
Object.
No, it's not.
All right, just one moment. All right, what is your objection?
Object to leading and also object to asked and answered.
Sustained.
It's fair to say that you don't know specifically which muscle broke down to cause her death.
No, we can't say.
So could you have been wrong with that?
I'm sorry.
Could you have been wrong in your analysis?
Object to
No.
argument.
All right, that'll be overruled.
No, I'm not wrong. It's just my opinion, and we agreed with the other doctors. It was quality control analyzed, so we had a discussion. So it's not just my opinion alone.
And nobody else was able to determine which muscle it was.
No,
That-
I don't think anybody can. That's not how it works.
Well, it's kind of important to be specific here.
No, I mean, as a doctor, we can only do so much.
Now, you notice that she was reported to have weakness and altered mental status for a few days. Who reported that? Do you know?
It's probably a hospital as well as the law enforcement agency.
And where would they have gotten their information?
I'm not sure. I don't know.
Who would have known prior to her death?
Whoever was taking care.
Whoever was taking care, yes.
Yeah.
Or not taking care, as the case may be.
Object to sidebar, Your Honor.
Sustained.
Reportedly, it says the decedent was reported to have weakness and altered mental status for a few days and was terminally witnessed to collapse suddenly and went unresponsive while being fed. Witnessed to collapse.
Your Honor, I object to her reading of a document that's not in evidence.
Sustained. You can ask your next question.
I'm considering, Your Honor. Now, you have a fact here, that there was evidence of terminal aspiration. What was that evidence?
Yes, like the food particles, a little bit of a microscopic evidence of possible in the lung alveoli.
In the report, you indicate that asphyxiation could not be ruled out. Do you recall that?
Yes, I do.
Would this be evidenced by the terminal aspiration?
No, it's nothing to do with that.
What does it have to do with, Your Honor? I'm Judge. No, doctor, excuse me. I'm sorry.
Well, I mean, so I did receive information from the law enforcement agency that in the past, there was evidence of loss of consciousness due to nose and mouth being covered, and that is a form of asphyxia. So what I'm trying to imply is if it happened in the past, I can definitely rule out that happened at the end.
You have a note here, as per the investigating police agency. And who was that?
The San Antonio police.
I subpoenaed, in addition to subpoenaing you, I subpoenaed the police records and medical records.
Object, Your Honor.
Sustained.
What I subpoenaed was not provided.
All right,
Did you-
excuse me, counsel. You need to ask a question. We're not here about your subpoena. You need to ask a specific question. State's objection will be sustained. Ask your question.
Did you receive any written medical reports?
Yeah, I probably reviewed medical reports as well as police reports.
Do you have the whole file in front of you there?
No, not the file, no.
Do you have your bench notes?
No, I don't. I have my report, which is the permanent record.
But you do make bench notes during the course of an autopsy, don't you?
Yes, that's for transcription purposes only.
Do you recall any particular notes that you might have made that were not provided?
No, I mean, anything important or relevant, significant will be in my report.
I'm sorry, significant what?
Information will be in my report.
You have a notice here that the investigating police agency in the past before death, the decedent was made to hold heavy objects and outstretched arms, and the upper extremities were strapped to a pole with bandage to hold them outwards. Do you remember where you got that information?
From the police agency.
And you have no idea where they got that information?
No.
Relevance.
Sustained.
There's a report here that the decedent was witness to suffer asphyxial events in the past. Again, that's only from police reports, not from your personal knowledge. Is that correct?
Not from my personal knowledge, no.
Why did you say that asphyxia could not be ruled out?
Check to ask and answer.
That'll be overruled. You can ask.
Well, what it is in a child with extensive trauma and with prior history of trauma, and especially with the history of asphyxial event in the past, I cannot for sure rule out the same happen at the end.
If her bronchial, if her windpipe was blocked, could that have been a cause of death?
Like I said, that is a very specific event. They need to have those specific findings, and the terminal circumstances should indicate that without any prior trauma or any injuries on the body, then it's a different scenario. So it's case by case basis, and that's not what happened here.
Is it too late? Your Honor, may I approach the witness?
No, he's on Zoom.
He's on Zoom.
Okay, she's on
Can she
Zoom.
approach?
I meant the court reporter, Your Honor, I'm sorry.
Yes, you may approach the court reporter.
Dr. Keenan, do you have the investigative report and an autopsy report in front of you?
I have the autopsy report.
And what is the case number on your report, which is different?
It's 2022-0365.
How do I short this?
All right, so here's my question. Is she seeking to admit that into evidence?
Yes.
Or is there going to be any objections to that being submitted into evidence?
Your Honor, I object to the state of it. It does have highlights, which
All right, does anyone have a clean copy?
I can print one off.
All right.
That first page.
Another one of these. That's it. I know, but could I have another? Just print it out.
Yeah.
Dr. Kanan, do you remember how many autopsies that you performed a year while you were here in San Antonio?
I mean, each year,
I'm sorry,
is it per year or,
when you were here in San Antonio for that year, 2020?
Oh. I don't know, probably more than 200?
Are you're familiar with Dr. DeMayo, Vincent DeMayo?
Yeah, I trained under him.
Back to relevance.
Overruled.
He said in his book that
Object to council testify.
Sustained.
if he were to say in his book that more than 230 autopsies a year is too much and it can't be accurate, would that be true?
Object to relevance.
That'll be overruled.
Object to hearsay.
All right, that'll be overruled. You can answer the question if you can answer.
Yeah, I mean, that's just an arbitrary number set by the National Association of Medical Examiners. They don't want each ME to go more than 250 autopsies. That's just a number.
Just a number. It doesn't,
Yeah.
in your opinion, does it indicate that there's not as much accuracy in those kind of cases beyond that? Thank you.
I mean, there are some offices, they have to do more than that, but ideal is should be below that.
All right, just one moment. Mr. Munoz, would you state, are you going to have any objection to, it appears they want to enter an exhibit?
I don't have an objection. Your Honor.
All right, what exhibit number is that?
Defense exhibit number 2, Your Honor.
All right, any objection to defense exhibit number 2?
No.
And for the record, what is exactly is defense exhibit number 2?
It's the investigative report of the medical examiner's office and the autopsy report.
All right, defense exhibit number 2 is admitted into evidence.
Thank you, Your Honor.
Just the autopsy. For clarification, Your Honor, it is just the autopsy report here labeled as defense exhibit number 2.
All right, that is admitted without objection.
Can we approach the court reporter?
Yes.
No,
I just,
is that the part you intended?
that's not what.
Please do.
All right, ask your next question.
Just a moment, Your Honor. Yeah, another. Oh. Your Honor, this is the second half of my exhibit that the state objected to because there were markings on it. And this is still exhibit D. Sorry, D2.
All right, you all want to label that as defense exhibit number 3? State, are you going to have any objection to defense exhibit number 3?
No objection. Your Honor.
All right, and what is, for the record, what is defense exhibit number 3?
Defense exhibit number 3 is the investigative report. The one that was sent in, when I cross-examined the doctor.
Stop, counsel. My question was, what is defense exhibit number 3?
The investigative report. of-
Any objection, state, for defense exhibit number 3 being admitted?
No.
All right, defense exhibit number 3 is admitted without objection.
Thank you. I'll pass the witness.
All right, state.
Okay, good morning, Dr. Cannon.
Good morning.
And I think we skipped introductions. You are now the Chief Medical Examiner in Nueces County, correct?
Yes, that's right.
When did you leave Bear County?
I left Bear County September of 2022.
Now, you mentioned earlier that this was a complicated case, correct?
Yes,
And you did the autopsy and then you looked at other evidence and you said you collaborated with other physicians.
yes.
And is it common in a case like Mercedes that it actually took a couple months to get the report back?
Oh, yes, yeah, because you have to put all the evidence in. When you don't have any one big diagnosis on the day of autopsy, we need to hold on and put everything together and make sure we have everything.
Okay. Now, I'm just going to go through some of the things you talked about to kind of solidify. So it is your testimony that the lip, based on the location and the state of it, that it was definitely from outside trauma, correct?
Yes.
Now, there was some question about, well, can this happen post-mortem? Isn't it true that living processes that like swelling and temperature control, they stop when you die, correct?
Yeah, I mean, tissue reacts different after trauma, and I could differentiate postmortem trauma versus trauma happened before because we are the experts in interpreting trauma.
Now, you said there was no evidence of sexual assault. However, you did notate that she had a dilated anus, correct?
Yes, that is the outside part, but I didn't really know what to make out of it.
Okay. And then you said there was no evidence of any trauma to her throat, correct?
No, no trauma.
And you mentioned a couple examinations for asthma. What were those?
First of all, when we open the airway, we are going to see some like mucus or like a slimy plugs obstructing the airway. I didn't see that. And also under the microscopic section, I did not see evidence of asthma.
Okay, so there was no physical evidence that she would have been having an asthma attack.
No, I don't think so.
The hyoid bone, that's something that is usually looked at if there's a suspicion of, say, suffocation by the neck, correct? Or strangulation, I should
Yeah,
say.
strangulation manual, we see that, and I don't think there is anything evidence of that here. No.
Okay, so if the medical history and what witnesses have said is that the defendant Jose Ruiz would put his his hand over her mouth and his hand
Objection,
over
Your
her
Honor.
nose.
Stating a fact not presented.
All right, that'll be overruled.
If the witnesses said that he would put his hand over her mouth and hand over her nose to restrict her airways, that would not impact the hyoid bone, correct?
No, that's way higher up. It will not show evidence in the hyoid.
And I just want to make this clear because this phrase terminal aspiration has been thrown around a lot. That means that the aspiration happened while somebody is already dying, correct?
In the process of dying, yes. That's nothing to do with the cause of death.
Okay. And rhabdomyolysis was something that was absolutely confirmed in Mercedes' case, correct?
Yes, we confirmed it by microscopic evidence, and we confirmed with the other doctors. Multiple eyes looked at it. Yes.
And you testified that rhabdo can be caused when the muscles suffer trauma, but it can also be caused from extreme exertion as well, correct?
Yes, it can, and those can be corrected if taken to the hospital immediately. And whereas here it looks like it's happened over time.
Yes, and independently, trauma such as Mercedes could cause rhabdo, correct?
Yes, it can. Yes.
But then also, if you had a 5-year-old like Mercedes who was forced to hold objects for 3-4 hours at a time over a 2 or 3 week long period, that would also explain rhabdo as well, wouldn't it?
Yes, because you're using muscles over a long period of time. It can happen. Yes.
So in Mercedes' case, where she has extensive injuries and there's evidence of long-term exertion of her muscles, it makes sense that she has rhabdo, doesn't it?
It adds up, all those scenarios.
And you would agree that rhabdo is treatable if taken responsibly when they start showing symptoms, correct?
Yeah, early stages, yes.
However, it does pose a substantial risk of death.
Well, especially in a thin individual and young child, they don't have much reserve.
Yeah. And when you say especially in a young child, what makes them more susceptible?
Well, in medicine, young and old are similar. They don't have like a well-developed adult, so they're vulnerable to disease.
So Mercedes, being a 5-year-old, was more vulnerable to being abused, basically.
Well, I mean, that's a general statement, but
Understood. I'll retract
Yeah.
that. Now asphyxia. When someone dies of asphyxia, would you consider that to be a sudden death?
it depends on the mechanism. If somebody's holding uh, the airway obstruction like nose and mouth, it still takes some effort to do that.
Would you expect somebody who has asphyxia to then vomit and start talking before they die?
No, I mean, if that is the cause of death, they should die as a result of that.
Okay, so asphyxia would happen and then they should die after that without.
If that is the only trauma, and then that is the end of it, yes.
Okay, thank you, Dr. Kanan. I'll pass the witness.
Defense?
Your Honor, I'm sorry, Doctor. I'm using you, but I respect you, and that's why I'm calling you Your Honor. Mrs. Mitchell mentioned to you, she used the word absolutely determined that it was rhabdo. Would you have used that word absolutely?
No, I mean, we are positive.
We are positive, but
Yes,
that's
positive.
absolutely.
I won't say absolutely, no.
I have a hypothetical. If someone was watching and saw someone jamming food down Mercedes' throat, and then Mercedes vomiting it out, trying to get rid of it, and that person were to jam a spoon down Mercedes' throat, and Mercedes then fell on the floor and had no breath, would that affect you at all if that was evidence put in front of you?
No, I mean, that mechanism doesn't sound right in this particular case. That doesn't fit the story
What story?
of the findings I see in the body.
But if you had been presented with that fact before you did all this, would that make a difference?
Well, even if it's presented, I would research into it, look into it. Like I said, it sounds like a choking death, which I have investigated many. We would particularly look into that, and I don't think there is any evidence of that here.
There was no evidence that you searched into it either. Was that correct?
I did not think that happened here because there was no facts presented to me, and then I did not see any evidence of that.
That's the point. No facts were presented to you about that. But if facts like this had been presented to you, would you have done your autopsy differently?
No, I mean, it wouldn't be any different. I would still do the same. And like I say, each case is different, each scenario is different. Uh, did that really happen in the case is question.
And again, it's impossible to say which muscles broke down. because-
No, I mean, we just say general because the test doesn't say which muscle did it.
It's not very precise though, is it?
No, I mean, it's not supposed to be precise. It's just to diagnose a breakdown
Why isn't it supposed to be precise?
because there is not particular a stain or a test which can distinguish each muscle. The skeletal muscles in the body are all the same. So
And there's no way to quantify.
no, we can't quantify. No.
It sounds very vague to me. Was it vague?
I mean, it's a phenomenon, and it's a known phenomenon, and we found evidence of it. So
But it also fits the narrative of the very badly damaged little baby's body, right?
I'm sorry, damaged.
It fits your narrative.
Objection argumentative.
Sustained.
Would you have been able to diagnose this as rhabdo immediately after the autopsy, or did you have to talk about it with your colleagues?
No, not immediately. We had to talk about it.
So you weren't able to determine immediately that rhabdo was the cause of death?
No, not immediately, no.
That's the witness.
No further questions, Your Honor.
All right, is this witness excused?
Excused and not subject to recall.
All right.
Thank you.
The rule has been invoked. Dr. Kanan, you're not allowed to discuss your testimony with anyone except for the state of the defense.
Thank you, Your
For
Honor.
zooming in. I appreciate it.
Thank you. Bye.
You're excused.
All right. If you all will bring out Miss Mendoza.
Yes, Your Honor. Call the district clerk. She's here.
Judge,
He
we
was
lost
here.
Todd. He was here. I guess he left.
Well, is the district clerk in the back?
It's understanding it's in the hallway, Your Honor.
All right, let's bring in the district clerk. Just one moment. And Deputy Laura, if you could check in the back to see if Todd Lachey is back yet. Thank you. I don't have those sheets.
Okay.
I don't have any things. So anything I'm asking.
Hello, if you would take a seat here, please. All right, if you could raise your right hand, do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up for members of the jury and the court reporter if you'll state your name for the record.
Donnie Gonzalez.
Ms. Donnie, my name is Teresa Conlon. Good morning. Did you bring the records that you have for Jose Angel Ruiz and Katrina Mendoza?
Your Honor, at this time, the state's going to object to the relevance of this witness and to ask for a voir dire outside the presence of the jury.
All right, ladies and gentlemen, I'm going to send you in the back briefly. Remember my previous instructions. Everyone, please rise for the jurors. I thought they took the clerk next because you had left, but after this witness, you'll be next. All right, everyone, please be seated. All right, State, you want to take the witness on board here?
Yes, Your Honor.
All right, you may proceed.
Good morning. What records were you requested to bring in?
On the subpoena, all indictments or charging instruments for Jose Ruiz and Katrina Mendoza.
And what did you bring with you, if anything?
None.
Why not?
There are no indictments.
I'm sorry, Donnie, what was that?
There are no indictments.
Are
In
you,
regard, I'm sorry. In regards to, related to murder or capital murder charges.
is that the sole extent that you were requested to come and testify from?
Yes.
Pass the witness, Your Honor.
No questions.
Your Honor.
So what's the relevance of
Exactly,
this
there's no
witness?
relevance.
It's relevant as to what they've been charged. This is a capital murder case. It's a child under 10. She's
No, this
murdered.
is not a capital murder case.
It's not charged as a capital murder case, but under Texas law, murder of a child under 10 is capital murder. And Ms. Donnie is just saying that there is no record of a charge of capital murder or even of murder in this case. And that's relevant to my case.
All right.
Your Honor, we would say that this is not relevant. Further, the witnesses or the jury knows what the indictment is. It was read to them and defense counsel read the entirety of Ms. Mendoza's charge. They are aware that there is no murder charge and this is not relevant.
All right, state's objection to this witness is going to be sustained. The court is finding that her testimony is not relevant. The court is basing that decision on the indictment that is before the court and the indictment that was read when the accused entered his plea of not guilty. In that indictment, there is no listing of a murder or capital murder. So you're excused.
Thank you.
All right.
Thank
and
you,
I-
Ms. Donnie.
I'm pardon?
Just said thank you to Ms. Donnie.
Thank you.
All right, if you'll bring out Miss Mendoza. Yes. All right. Mr. Todd McCray, where are you? Okay.
Verna, can we have a break, a bathroom break, rest
Uh,
break, whatever you want to call it?
5 minutes.
Thank you.
Can you let her know 5 minutes? And while they're doing that, Donna, are you able to switch over or do you need a break? For their State's Exhibit 1? Yes, you can take a break after them. You can take a break after them. Yes. All right, come forward. Yes.
We've come to an agreement and have an exhibit for substitution.
No, no, no.
I don't know.
All right, so just tell me what's going on. All right, so we're going to go on the record. All right, and let me call the case number. Let me see. Do you all have do you have the document from the 13th court? All right, if you can forward the email, I may have it, just one moment. Oh, I have it. And then we'll put everything on the record and have the exhibit marked. All right, I think you all have the Zoom link. Yes, I'll write it down again. All right, we're going to go on the record. Under the Court of Appeals of the 13th District Court of Texas, their cause number is 13-23-00572-CR. Could I have parties announced, please?
Daniel, I'm 12 and 6.
All right. And sir, you are the appellate attorney for Mr. Wilson? All right, the court received an order of abatement from the 13th court. It was in regards to State's Exhibit number 1 as being unviewable. Have both parties had a chance to review the request from the 13th court? All right. And my understanding from an off-the-record discussion is State, you were able to duplicate State's Exhibit number 1 that was originally submitted?
Yes, Your Honor. We were able to download it from Discovery and then I was able to.
And trial counsel, Mr. Cornelius Cox, were you all able to have discussion with him? All right, then it's the court's suggestion, since we already have State's Exhibit number 1, if you will label it State's Exhibit number 1A. So that way, both will still be in the record. And for the record, State's Exhibit 1A is a duplicate of State's Exhibit 1. Is that correct, counsels? All right, and attorney, Mr. Cox is in agreement that that is State's Exhibit number 1. All right. right, is there anything else before we close the record? All right, then the record will be closed. Yes. All right, and then what we'll need to do is will the court reporter, Mary Scopus, have to submit that to the 13th court? All right, thank you. All right, Diana, you can take your break. Thank you.
Sorry.
Dinah just need to take a short break and then we'll bring them out and we'll bring her out.
Thank you.
All right, thank you. All right, thank you. And Deputy Laura, could you give them the Zoom link again? They have another witness they want to appear by Zoom. If you could mute us, please.
Well, I mean, I would just say.
All right, for the jury.
Mhm.
All right, everyone, please be seated. Defense, call your next witness.
State, defense calls Katrina Mendoza. He's gonna testify? Yes.
All right, you're still under oath. Make sure that you keep your voice up so that members of the jury and the court reporter can hear. Defense?
Good morning, ma'am. When was the last time that you actually lived with Jose Angel?
During the month of January in 2020. 21 and 22.
You don't know for sure?
No, I don't know for sure.
Were you living with him on January 13th,
Of what year?
2022?
I think so, yes.
Would you have sent him texts if you were living in the same house with him?
Yes.
You recall a text where you were complaining about you couldn't take much more of Mercedes. Do you remember writing a text like that? Let me make it stand.
Yes, probably.
You remember telling him that
I'm gonna object to reading from items not in evidence.
Sustained.
did you ever tell him that you made Mercedes?
Again, judge, same objection.
All right, let me hear the question.
Did you ever tell him that you made Mercedes in timeout hold her arms up for 2 days in a row?
No,
Did you ever tell him that you couldn't have her with you much longer because you were afraid of what you might do?
no.
What was your phone number?
I don't remember.
Would it have been 210-551-0891?
I'm gonna object to reading.
Overruled.
I'm not sure.
Did you say at any time, I'm either gonna live with my stepfather or whatever, I'm sorry, whatever he was called, and your biological father? Do you remember ever saying that to him?
Can you repeat the question?
Do you remember ever saying to Jose that you were gonna find a different place to live?
No,
That you were deciding between your godfather and your biological father?
I don't remember.
Did you ever tell him that you had to get a stable place to get the children in school?
Yes,
So they really weren't in school in January or February of 2022. Is that correct?
no, they were enrolled.
They were where?
They were enrolled.
Where?
I don't know the name of the school.
Did they attend that school at all in January?
I can't remember.
How many children did you have?
2.
Was Mercedes in school at all?
Yes.
Where?
I can't remember the name of the school.
Was she in a school or was she in a daycare?
School.
Was it a free school or was it a paid school?
Object to relevance.
That'll be overruled. You can answer the question.
It was a free school.
In order to get her into that school, do you remember what address you might have used?
1106 Caspian Point.
I'm sorry, 1106,
Caspian Point.
and where was that?
In 5 Marbach and Fulton.
And who lived there?
My godfather, my godsister, my 2 little brothers, and my godsister's husband,
And you too, is that right?
and me and my kids, yes.
So they only went to that school when you were staying at that house, is that true?
Yes, ma'am.
On January 12th, I'm sorry, 13th of 2022, do you recall telling Jose that you had Mercedes hold her arms in the air for 2 days in a row? When she got up the next morning, it started 2 full days. Do you remember telling him that?
No,
So if it's in an email, it must be a mistake.
I'm not sure. I don't remember seeing that.
You were saying that Jose beat your child to death about 3 weeks before her death. Do you remember that?
What I meant was his abuse caused her death, yes.
It couldn't have been the abuse that you caused on January 13th of 2022.
No,
What did you do to your child that day? Do you remember?
no.
If you have a text that says you did something, did you lie in texts?
Sometimes I would lie to Jose about what I was doing just to avoid an argument. Yes, witness.
State.
I have 1 second here. Katrina, for what purpose would you lie to Jose about what you were doing with Mercedes?
Because he would get angry if I treated her a certain way, so I knew what he wanted to hear, so sometimes I'll just tell him what he wanted to hear to avoid an argument or to get physical altercations or just to avoid an argument.
And what did he want to hear?
That I was punishing Mercedes in any type of way.
Okay. And you were living, you just testified you were living with your godfather, that's Homer, correct?
Yes, ma'am.
Okay, but on January 21st of 2022, there was an altercation and you moved out, correct?
Yeah, around there, yes.
Okay. And prior to you leaving Homer's home, Mercedes the day before had gone with Jose.
Yes.
And there was testimony and defense asked you questions about that you had said that Jose had beat Mercedes 3 weeks prior to her death. Isn't it true that you're actually meaning he beat her for the 3 weeks, prior to her death?
Yes, that's exactly what I
Not
mean.
just 3 weeks ago.
Yeah.
Okay. Ask the witness.
3 weeks, the 3 weeks prior to her death. You testified on my direct examination that he hadn't seen the children for 2 days before her death. Was that a lie?
Can you ask again?
You testified on my direct examination that Jose had not seen the children for 2 days, 2 full days prior to her death.
Yes, that's true.
It is true. Definitely didn't see them. And at that point, say the 3rd day, where were you living?
I was staying with Jeanette.
Same with Jeanette. What kind of an altercation was it that you had at your godparents' home that you left?
We got into it because Jordan was playing with one of my little brothers and I got upset for some reason, I don't remember, but I confronted my godfather Homer about it and he kind of didn't want to like get after his son for, I think they were fighting over something, him, Jordan and my little brother. And I told my godfather and he didn't really like, he kind of just pushed it to the side, he didn't address his son about it. So I got upset and my godfather kind of pushed me. And so,
I'm sorry, physically pushed you?
yes,
Where were you when this happened?
Object to relevance.
Sustained.
Were you in his house when this happened?
yes,
What part of the house?
I'm gonna object to relevance.
Sustained.
You say he pushed you. He took his hand and threw it against your body, is that right?
I'm gonna object to relevance and ask and answer.
Sustained.
How did he push you?
Object to relevant.
Sustained.
Isn't it true that the fight was really about how badly you were treating Mercedes and they had gotten sick of it?
no,
Isn't it true that on the 21st, when this supposedly happened, that the CPS worker had been to your house there?
Object to leading.
That'll be overruled. You can answer the
No.
question.
What day was she there?
I don't remember, but it wasn't the day before we left.
But it was around then, wasn't it?
No, about like maybe 2 weeks before we left.
2 weeks before you left. What are we talking about in terms of time here? You left on the 21st?
No, I believe I left on the 22nd.
22nd. And if the witness testified that it was the 21st of the last appointment, that would be a mistake, is that right?
I'm not sure, I don't really remember, so I could be wrong.
In the course of his testimony, you've remembered some things very clearly and other things not at all.
I'm gonna object to argumentative.
Overruled. And ask your question.
Overruled, Your Honor?
Ask your question.
Can she answer that? If you overruled?
Yeah, ask your question. And she'll answer it if she can.
I'm sorry, Ms. Diana, would you mind reading it back?
In the course of this testimony, you remembered some things very clearly and other things not at all.
Thank you. Why is that?
Cause it's been 2 years,
3 years?
2.
2 years. And is there anything else more significant in your life than something like this that you would forget it?
There's just some things that I don't remember.
That you don't want to answer or that you don't remember?
That I don't remember.
Your Honor, I'd like to show the witness testimony of her daughter, Jordan. I need help with the state putting it on.
There's a lot of evidence. We'll get it then.
They're grabbing a distract.
Might be one. Hold on. Here we go. We got one.
All right. Ask your question as it relates to this exhibit. What question do you have of her?
I have to put it on your arm. I wanted to see it and then I'll ask. the
All right,
question.
no, that's not how it works, but
Did you ever talk to your daughter Jordan the day after Mercedes' death was announced?
No,
I would like to get your opinion on what your daughter said about you.
No objection.
Objection?
I'm sorry to interrupt. I thought she was done. I'm an object irrelevant.
that will be sustained.
If your daughter said that you were jamming food into Mercedes' mouth and Mercedes was spitting it out, would that be true?
no,
If Mercedes was spitting out globs of food, would that be true?
no.
Why were you feeding her anyway?
I wasn't feeding her, she fed herself, but I gave her food because it was time to eat.
What time was it?
Maybe about 1:30 to 30 o'clock in the afternoon.
Was she on a regular meal time?
Object irrelevant.
That'll be overruled.
No,
What food do you recall giving her at 1:30, 2:30, whatever?
well, due to the swelling of her mouth and the missing teeth that she had, I gave her soup, I gave her bananas, I gave her yogurt, I gave her water.
You didn't shove it in her mouth.
No,
Jordan was lying.
I believe she's been coached.
Who would have coached her?
I'm not sure because I didn't have her right before, when I was in the hospital, she was not with me.
Where was she?
She was with Jose and Jeanette.
And who would have coached her about what she said?
Objection, speculation.
Sustained.
The witness testified that somebody coached her. What I'd like to ascertain is who would have coached her?
Right, the objection has been sustained to speculation.
So do you retract your statement that she was coached, since it's all speculation?
All right, the court makes its rulings. I have ruled that with regards to speculation, the objection is sustained. Ask your next question.
I asked her, Your Honor,
That will be
She
sustained.
retract-
Ask your next question.
would you retract your statement that she was coached?
Objection, argumentative, speculation, relevance.
Sustained.
I'd like to put that video on now, Your Honor, because of prior inconsistent statements and for impeachment.
It is not her statement. It's someone else's statement. That will be,
I'll object, Judge. That's not proper impeachment.
all right. You're not allowed to do that. It's not proper impeachment.
Was sustained?
Yes.
Thank you. That's it. We'll pass the witness, Your Honor.
No further questions, Judge.
All right, is this witness excused?
Yes, Your Honor.
From the state.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone. Do you understand?
Yes.
All right, you may step down.
Testify. We find out.
All right. Defense, call your next witness.
Your Honor, I don't believe she came. It was the pediatrician, but as far as I know, she's not here. If you could just give us a moment. Are you going to testify?
All right, ladies and gentlemen, I'm gonna have you all step outside for 5 minutes. Remember my previous instructions. And State, I'm gonna have you step out in the hallway while she discusses things with her client.
Yes, Judge.
All right, everyone, please be seated. And Mr. Porter,
Some more.
Mr. Porter, if I could see you, please.
Yeah.
orders, brought it to the bailiff's attention, to bring it to the court's attention. I say that because I just know this is a jury that has been very conscientious about following the court's orders and remaining impartial. And so I spoke with my bailiff this morning, indicated nobody has made any references to him or any comments about anything, and I don't see a need to now hold the jury because there was coverage this weekend. Again, there's been coverage last weekend as well of this trial. There's been extensive coverage of this trial, and I am confident that the jury has followed the court's instructions and is fulfilling their duties as they ought. So I'm not going to bring them in old ones. But we did want to make a record. So Mr. Johnson, the record has been made and preserved. So thank you. Anything else before we bring in the jury?
Nothing official.
Moving on. Okay, let's bring in the jury. Thank you. You can be seated. Welcome back, members of the jury. I hope you had a good weekend. And we're back on record now for trial. Mr. Johnson, you may call your next witness.
Chet Gilmore.
Chet Gilmore. Good morning, sir. Good morning. Please step forward and face my clerk and raise your right hand, please.
Do you solemnly swear that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You're welcome to have a seat there in the witness stand. As best you can, if you would speak into the mic.
Yes, sir.
I'll let you begin. You may inquire, Mr. Johnson.
Thank you, John. Good morning.
Good morning.
Can you please state your name and spell your name for the record?
My name is Chet Gilmore, Gilmore, Chet, Chet.
And where do you live?
I live in Spokane, Washington.
What do you do for work?
I'm a private investigator.
And how long have you been a private investigator?
About 10 years.
Can you briefly explain to the jury your training and background?
Well, I had a 25-year law enforcement career. That was in Spokane. So I did all of the normal learning to be a policeman training and spent about 14 years as a major crimes investigator. So myriad of various trainings to do with homicide, evidence collection, everything you can think of probably to do with a major crime investigation. And then, so after 25 years, then I retired from Spokane and became a private investigator. And during the course of that, I've done civil investigations, family investigations, but the majority of my work has been involved in criminal defense investigations. And really, the whole gamut of types of criminal allegations.
Did you have an opportunity to participate in the investigation of Mr. Gilmore?
Of Mr. Howard, yes.
Oh, sorry, yes. Did you review discovery in this matter?
Yes, I did.
In general, what did that include?
Oh, it included much documentation, paperwork, officers' reports, evidence reports, a lot of photography, a lot of videography, both from officers, body-worn cameras, and purposeful cameras at the scene to document the scene.
Okay. Now, when dealing with photos, is there a way that you can look at the properties of a photo and determine when those photos were taken?
Sure.
Can you explain?
Well, a photo has not just a visual photo of what you can see, but there's data or metadata that is embedded within the digital data of the file that you can open up and look at when it was last modified, but also when it was taken, when the photograph was taken, as long as that hasn't been stripped from the photo in some type of a transfer process or something.
Okay. Did you have an opportunity to look at photos taken by Deputy Wheeler?
Deputy Wheeler, yes.
Permission to approach, Your Honor?
Yeah.
In looking at did you have an opportunity to look at the data or metadata for the photos for Deputy Wheeler?
Yes.
Were you able to determine a range of when he took those photos?
Yes. I made some notes. Can I bring that out so I have the right time?
Would that assist you in your answering this question?
Yes.
Your Honor, permission for Mr. Gilmore to review his notes?
If he needs to refer to his notes for your questions, then I'm ready.
Okay. And your specific question is?
What is the time frame that Deputy Wheeler took his photos while he was on scene?
What I made note of was the time that he took photos that included the bathtub area of the scene.
Okay.
And that time frame is February 2nd, 2021 at 11:24 p.m. until February.
Common objection is reading from the document that hasn't been admitted into evidence.
Were those your notes you were looking at to refresh your memory?
These are the notes that I wrote down when I was looking through the photos and checking the metadata on the various photographs.
Oh, so I'll ask you not to testify from your notes. But from
Okay.
your memory.
Sure.
Have you had a chance to refresh your memory on Deputy Wheeler's photos?
Yes.
And what was the range, time frame?
The beginning range was 11:24 p.m. past midnight to 12:29 a.m.
May I approach the witness, Your Honor?
You may.
The question was admitted as State's Exhibit 16G. Do you recognize that photo?
I do.
Is this one of the photos that was taken by Deputy Willard,
Yes.
and that would fall within that time frame?
Pardon me?
That would fall within that time frame?
Yes, it would.
Did you also have an opportunity to review photos taken by Detective Northrop?
Yes, I did.
Were you able to identify a time frame of when those photos were taken?
Yes, I was.
Do you remember what they are?
Yes.
And what were they?
It's spread out over a longer period of time. At the very beginning of those photographs that actually showed the bathroom tub area was at like 6:03 a.m. on the 3rd, February 3rd of 2021. Those were a little bit distant because they looked like they were from the doorway, so you didn't have much clarity. Once the photographer moved closer and started taking photographs, that was at 6:05 a.m. And then the officers appeared to be there for several hours, and there were a series of different times when the photographer would come back to the bathroom. And it's kind of hard to tell exactly where the break is from what's in the tub and when the decedent may have been removed from the tub. But the ending photographs all the way up until there was a body bag was in the afternoon. Looks like, excuse me, not afternoon, it was in the morning, 2.5 hours later, almost 3 hours later, 8:58 a.m.
Were you provided autopsy photos in this matter?
Yes. All right, we're back on the record. Defense,
Are you familiar with those records that were shown to you, sir?
Some of the ones that are not involving the child death, I am not familiar with those. No, ma'am. Those are cases from before this.
Okay, how far back did you go?
I looked at that document that he showed me.
Which one was it? Mhm. You didn't look at all 6,015 pages, right?
And I was scrolling through most of them. Yes, ma'am.
Okay. Did you see a train in there where there was any connective tissue that would follow through?
I'm gonna object to with him testifying to anything in the records that were not admitted into evidence.
all right, that's going to be overruled. You can answer the question if you know the answer to the question.
Object to relevant.
All right, you can answer the question if you know the answer to the question.
Ma'am, the connective tissue is maybe that it's Mercedes Lasoya. It's Jordan Lasoya and her mother, Katrina Mendoza.
Yes.
And then I also seen the father as well.
So was it helpful for you to see them at all?
Helpful in what way, ma'am?
In that you're able to understand what's going on with this case other than the death of Mercedes?
Again, ma'am, my focus was in on the child death portion of that.
Maybe I asked for the wrong witness. Who would I ask for that has the overall picture on how to save a child?
I'm gonna object to relevant.
Sustained,
Who should I have called instead of you?
I'm gonna object to relevant.
sustained.
Yes, witness.
Any questions?
Just one, Judge. Mr. Adami, you mentioned that Katrina Mendoza was an alleged perpetrator. Were there any other alleged perpetrators?
I'm
Yes,
sorry, I didn't understand that question.
I said-
Rebecca.
I said you testified that Katrina Mendoza was an alleged perpetrator. Isn't it true that Jose Ruiz was also an alleged perpetrator?
yes, ma'am.
Pass the witness.
No further questions, Your Honor.
All right, is this witness excused?
Yes. From the state.
No recall, Your Honor. He doesn't.
All right, the rule has been invoked. What that means is you can't discuss your testimony with anyone or watch anything. The only persons you can speak to are attorneys for the state or the defense.
Yes, Your Honor.
Thank you. Defense, call your next witness.
Your Honor, I'd like to call the district clerk. Justin out there.
And Your Honor, we would object to this on relevance.
All right, we'll see what the district clerk has to say.
Your Honor, this could be avoided if the state will stipulate.
No.
Your Honor.
Here's, stop. Witnesses need to be called. The court will hear any objections at that time. The requests for stipulations need to be done outside the presence of the jury, and I think both parties are aware of that.
No, Your Honor, I'm sorry, I wasn't.
All right. The requests for stipulations need to be outside the presence of the jury. And everyone just give us a moment.
Your Honor, apparently, the clerk isn't here yet. I'd like to instead call recall Katrina Mendoza.
All right, if deputies, if you all could bring Katrina Mendoza.
Yeah, I haven't called.
And ladies and gentlemen, I'm going to have you all step outside for a moment because since Miss Mendoza is being called back, her attorney needs to be here as well. So remember my instructions. We're off the record, Donna. You're not allowed to view anything. You're not allowed to start deliberating individually with yourself or with each other. You're not allowed to watch anything or do any investigations. Does everyone understand? All right. And I assume the room is open for you all? The jury room? Okay, just give us a moment. We'll take you all back, okay?
Can't call him? Okay. Can you find that?
All rise for the jury.
Yes. But not even all that background. I had a pad here with those kind of numbers on it.
Has anybody called Todd McRae?
Yes, I just texted him. He's 10 to 15 minutes out. Additionally, Judge, I was in contact with Dr. Cannon and gave his cell number to defense, so they can.
All right, actually, Dr. Cannon is on now. Would you all like to call him?
Yes, sure.
Dr. Cannon's on.
Absolutely, yeah.
All right, can you let the jurors know that he come back in? We'll take up Dr. Cannon then.
Good for him.
Lina, happy Monday.
Oh, I'm just. You're
Let me go get that away.
Yes.
No, no problem. These are what we call Mondays.
Oh, here we go. It got underneath. It's underneath her CV.
So then what we'll do, defense, we'll call the doctor. You all are calling the doctor?
Yes, sir.
Then we'll see what the ETA is of Todd McRae. And then if somebody will pick up the phone and just call the district clerk, I'm sure the district clerk would either come or send one of her deputy clerks. If you all want to ask the employees of the district clerk's office who are in the back, I'm sure they would call.
We're in Martinez. Well, Justin was doing it this morning, Tony.
All right, if you'll tell them just come in.
All rise for the jury.
Then if you let them know when they come up, that they can keep her on hold over. Everyone, please be seated. All right, Dr. Cannon, if you could unmute, please, and start your video.
Where is it showing your arm?
He needs to unmute and start his video.
Where is it showing?
It's gonna show it.
It's not showing yet because he hasn't unmuted or started his video.
Where will it be shown?
It's right here on the screen.
Thank you.
All right, Dr. Cannon, if you'll unmute, please. All right, if you can make sure you keep your voice up so that we can hear.
Oh, yes, ma'am.
Awesome. All right, defense, call your next witness.
Good morning, Dr. My name is Teresa Connell.
No, call your witness, counsel.
I'm sorry.
All right.
I'd like to call Dr. Kanan.
All right, you may be seated. Dr. Kanan, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand, state your name for the record, please.
Yes, my first name is Rajesh, Rajesh. Last name Cannon, Kannan.
All right, this witness is appearing by Zoom. Any objection to the witness appearing by Zoom? State.
No objection, Your Honor.
Defense, any objection to the
No
witness
objection,
appearing
Your
by
Honor.
Zoom?
No objection.
Mr. Ruiz, any objection to this witness appearing by Zoom? All right, defense.
Morning, sir.
Good morning.
You're here specifically regarding the autopsy that you performed on Mercedes Lozoya on February 8th of 2022. She died on the 7th, but it's my understanding you performed the autopsy on the 8th. Is that correct?
Yes, ma'am.
Okay, and do you have those papers in front of you?
Yes, I do.
Okay. Going through the whole record, which is extensive, your first contact about this case was with whom?
It's really when I saw the case.
You recall speaking with Detectives Lawrence Size?
It's probably at the time of autopsy,
When was the time of autopsy?
on February the 8th, 2022.
At what time?
It's about 9 o'clock, 9 a.m.
And how long did it last?
Autopsy, probably a few hours.
You don't remember specifically with this one?
No, ma'am.
Is it noted on the form anywhere? I didn't notice it.
No, it just whenever we finish them.
I'm sorry, sir, what did you say?
Whenever we finish,
Whenever you finish.
yes.
You don't necessarily notice when you finish, though.
No, we don't.
So, when you started the autopsy, I imagine, did you observe the outside of the child's body first, or did you go inside? What is your
Oh,
procedure?
no, it's a routine to look from top to bottom, outside, document, take photographs, and then we'll look inside.
Did you reach any conclusions from the observation outside?
I did the observation outside, yes.
Did you make a decision based on what you saw?
No, ma'am, we have to go inside and then wait for every test, and then we have to decide.
What kind of tests were you waiting for?
In this particular case, I did do additional microscopic examination of the tissues.
Which tissue was that? A particular place?
Yes, we did the comprehensive study on all the tissues, major organs, including heart, lungs, liver, adrenal gland, pancreas, spleen, thymus, intestines, and then also the kidneys, portion of the skin. And the kidneys, I did additional tests for a stain for myoglobin, which is myoglobin.
Now, when you performed the autopsy, you didn't have any prior information, is that correct?
Prior information,
Prior to that child being on your table?
no, it all started at the time of autopsy and after the autopsy. We met with the detectives.
Excuse me, Dr. Cannon, I know you're probably having difficulty hearing, but when an objection is made, I'm going to need you to stop talking so I can make a ruling on the objection. And
Okay.
attorneys need to use your microphones. All right, you may continue, Dr. Cannon.
It's at the time of autopsy and after.
Who was present with you when you performed the autopsy?
It's from the law enforcement. I believe it's Detective Sains, but I could be others. I can't remember.
It's not specifically noted who was there?
No, ma'am, no.
When you looked at Mercedes, when you looked at her, you didn't have any initial first impressions?
Object to leading.
That'll be overruled. You can answer.
Yes, yes. First impression is yes. This child suffered trauma.
How much trauma?
Well, it's extensive from top to bottom, all over the body.
Was Dr. Molina present when you were doing this?
No.
I'm
All right,
sorry,
that'll be overruled. You can
No,
answer.
ma'am, no,
she was not present.
no.
Okay. When you do an autopsy, do you have anybody helping you?
No, it's just me.
And possibly Detective Size?
Yes, if they come for observation, we allow them because they're the lead law enforcement agency.
There was evidence of medical intervention. Your notes indicate defibrillator pads are present on the chest wall.
Yes, ma'am.
Needle puncture is present just above the right knee.
Correct.
And intro.
Osseous.
Thank you.
Yes.
Needle is inserted in the left shin.
Yes.
And that indicated that somebody tried to save the child?
Yeah, it's from the hospital. It's pretty routine to see this.
All right, now, the first note I have here is that the head. What do you recall about Mercedes' head?
Yes, I listed on each section because the injuries are pretty all over. So the head had a lot of abrasions or scrapes, and on the front, back, cheek, and also the back had a small a tear of the skin as well.
Where was that, sir?
In the back of the head.
The top? What part
In
of
the back. In the back.
Plain old center back, or?
Yes.
And what do you think that was from? Could you tell?
It's a blunt trauma.
Blunt trauma?
Yes, ma'am.
Would you have considered that a cause of death?
No, that's not alone as a cause of death.
But was it significant enough that potentially it could have been a cause of death?
Like I said, we don't infer just on one small tear. It's the overall picture which matters.
Yes. So that tear wasn't enough to give you a distinct impression at that point?
No, not at this point, no.
Okay. You talked about Mercedes' lip.
Yeah.
Broad 5 by 3 centimeter area of erosion with overlying superficial layer of thin tan granulation tissue. What does that mean, granulation tissue?
It's
I'm sorry, Your Honor, I'm gonna object to her reading from a document that's not in evidence.
All right, that'll be overruled.
Yeah, what it means is it's a tissue trying to heal.
What part of the face was it?
It's on the inner side of the lip.
Inside her lip.
Yes.
Could you ascertain what the source of that injury was?
No, we can't tell.
Like a child biting the inner side, inside of their
No,
mouth?
it's not biting. It could be any kind of trauma on top of the lip.
Did you notice some missing teeth?
Yes, I did.
Do you remember how many?
A few.
Was it unusual for a child of this age to have missing teeth?
I mean, one is we can happen if they fall, but quite a few with overlying trauma with different stages of healing is not common. It indicates there is some repeated trauma.
For how long a period?
It's probably days.
Days?
Yes, ma'am.
These were her baby teeth, as we lay people call them. Was
Yes,
that what-
these are. Yes, that's right.
Give me with these words, but present on the proximal mid-occipital scalp head are two contusions measuring 2 by 3 centimeters. What is that?
It's on the back of the head are contusions or bruise.
Were these recent?
They appear recent. Yes.
And when we say recent, are you talking in terms of hours, days?
I would say days.
Have you, at this point in time, begun to formulate a cause of death in your mind?
No, because these are complicated case, and we need to gather all the information.
Why was it complicated?
Because when I also need to look inside the body, not just outside. And inside the head, I did not see any obvious immediate cause of death.
So it was not, is it fair to say it was not the focus of your examination, her head?
Head is the main part of the examination, but I also look at other cavities like chest and abdomen.
Abdomen. We talk about a cluster of 3 contusions measuring 1 to 2 centimeters present on the lower left abdomen above the inguinal region. Was this done with, can you ascertain what caused these injuries?
It's just some kind of blunt trauma, and I can't really tell exact mechanism how it happened, but there is some trauma.
Thank you. Talk about her fingers being swollen. What is that from? Was there an obvious injury there, or? why
No,
would-
what it is it's an injury, but the tissue is reacting to the hand, and that it's swelling is common in injury.
Even post-mortem?
Well, it's around the time of death, so yeah, I can still observe it.
But it was observable, that's that.
Yes.
And her arms had several different kinds of contusions, is that correct?
Yes, that's right.
There was no evidence of sexual assault. Am I correct?
I did a complete examination and collected trace evidence. I'm not sure if it was submitted, but based on my exam, I examined the inside of the anal canal, vaginal canal. I did not see any tears or trauma.
Thank you. At any point, did you examine her throat?
Yes, inside, yes.
Did you see anything there?
But no, I could not see anything.
There was an allegation against the mother in her indictment that she had shoved a utensil down her throat. Did you observe any injuries from that?
I mean, not at the time of death, no, ma'am. No, there was no evidence of trauma.
Inside her throat?
That's right.
The child, did you know the child had asthma? Was that obvious to you?
I looked for signs, but I did not see anything
You did not.
obvious in the body. Nothing in the body.
Typically, if a person came before you and had asthma, is that something you would notice right off the bat, or you'd have to
No.
look for?
No, because asthma, remember, they don't come to medical examiner. It's a treatable condition. And we have signs of asthmatic attack when they go to hospital. Typically, they tell us what happened. And we kind of already know what to look for. In this case, that was not obvious.
But have you seen deaths from a bad reaction to asthma?
Oh, yes, yeah.
You did a full dissection of Mercedes' back, is that correct?
I examined, yes.
It says a full dissection of the back.
Yes, yes, ma'am.
Now, I've seen autopsies on television, forgive my lack of knowledge. Do you turn the child over to examine the back or?
Correct. Yes, we have to.
Okay, and you cut the back as well?
Yes, yes.
Specifically, what did you observe that could have caused her death?
Well, I mean, like I said, all the injuries in the back, like around the buttocks, there were blood seeping into the deep tissues, which indicates the injuries I observed on the top went a little bit to the bottom. But again, these are only skin.
Relevant. I'm sorry, 1 second. How did he push you? Object to relevant.
Sustained.
Isn't it true that the fight was really about how badly you were treating Mercedes and they had gotten sick of it?
No,
Isn't it true that on the 21st, when this supposedly happened, that the CPS worker had been to your house there?
object to leading.
That'll be overruled. You can answer the
No.
question.
What day was she there?
I don't remember, but it wasn't the day before we left.
But it was around then, wasn't it?
No, about like maybe 2 weeks before we left.
2 weeks before you left. What are we talking about in terms of time here? You left on the 21st?
No, I believe I left on the 22nd.
22nd. And if the witness testified that it was the 21st of the last appointment, that would be a mistake, is that right?
I'm not sure. I don't really remember, so I could be wrong.
In the course of his testimony, You've remembered some things very clearly and other things not at all.
I'm gonna object to argumentative. Overruled. And ask your question.
Overruled, Your Honor?
Ask your question.
Can she answer that? You
Yeah,
overruled?
ask your question. And she'll answer it if she can.
I'm sorry, Miss Diana, would you mind reading it back?
In the course of this testimony, you remembered some things very clearly and other things not at all.
Thank you. Why is that?
Because it's been 2 years,
3 years?
2.
2 years. And is there anything else more significant in your life than something like this that you would forget it?
There's just some things that I don't remember.
That you don't want to answer or that you don't remember?
That I don't remember.
Your Honor, I'd like to show the witness testimony of her daughter, Jordan. I need help with the state putting it on.
There's a lot of evidence. We'll get it then.
They're grabbing a distract.
All right. Ask your question as it relates to this exhibit. What question do you have of her?
I have to put it on, Your Honor. I want her to say it and then I'll ask. the
All right,
question.
no, that's not how it works. But
Did you ever talk to your daughter Jordan the day after Mercedes' death was announced?
No,
I would like to get your opinion on what your daughter said about you.
No object to
That's- Objection?
I'm sorry to interrupt. I thought she was done. I'm an object irrelevant.
that will be sustained.
If your daughter said that you were jamming food into Mercedes' mouth and Mercedes was spitting it out, would that be true?
no,
If Mercedes was spitting out globs of food, would that be true?
no.
Why were you feeding her anyway?
I wasn't feeding her, she fed herself, but I gave her food because it was time to eat.
What time was it?
Maybe about 1:30 to 30 o'clock in the afternoon.
Was she on a regular meal time?
Object to relevant.
That'll be overruled.
No,
What food do you recall giving her at 1:30, 2:30, whatever?
well, due to the swelling of her mouth and the missing teeth that she had, I gave her soup, I gave her bananas, I gave her yogurt, I gave her water.
You didn't shove it in her mouth.
No,
Jordan was lying.
I believe she's been coached.
Who would have coached her?
I'm not sure because I didn't have her right before, when I was in the hospital, she was not with me.
Where was she?
She was with Jose and Jeanette.
And who would have coached her about what she said?
Objection, speculation.
Sustained.
The witness testified that somebody coached her. What I'd like to ascertain is who would have coached her?
All right, the objection has been sustained to speculation.
So do you retract your statement that she was coached, since it's all speculation?
All right, the court makes its rulings. I have ruled that with regards to speculation, the objection is sustained. Ask your next question.
I asked her, Your Honor.
That will
would
be
she
sustained.
retract-
Ask your next question.
Would you retract your statement that she was coached?
Objection, argumentative, speculation, relevance.
Sustained.
I'd like to put that video on now, Your Honor, because of prior inconsistent statements and for impeachment.
It is not her statement. It's someone else's statement. That will be,
I'll object, Judge, that's not proper impeachment.
all right. You're not allowed to do that. It's not proper impeachment.
Was sustained?
Yes.
Thank you. That's it. We'll pass the witness, Your Honor.
No further questions, Judge.
All right, is this witness excused?
Yes, Your Honor.
From the state.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone. Do you understand?
Yes.
All right, you may step down.
Testify. We find out.
All right. Defense, call your next witness.
Your Honor, I don't believe she came. It was the pediatrician, but as far as I know, she's not here. If you could just give us a moment. Are you going to testify?
All right, ladies and gentlemen, I'm gonna have you all step outside for 5 minutes. Remember my previous instructions. And State, I'm gonna have you step out in the hallway while she discusses things with her client.
Yes, Judge.
All right, everyone, please be seated. And Mr. Porter,
Would you look up some more?
Mr. Porter, if I could see you, please.
Yeah.
you recognize this?
As a summary of our results, yeah, it's biomechanical results.
K14, do you recognize this?
As a separate test of blood pooling, yes.
And then K15, do you recognize this?
I do. That's a video that we provided with the report.
Are these portions of what went on to a PowerPoint?
Yes, sir.
And do you recognize what's marked as K17?
Yes.
And is that your initials on it?
It is.
Would referring to this information with the redactions noted, but would this assist you in your testimony today?
I think it will assist the jury in understanding what we've done, yes.
Okay. Your Honor, move for admission for demonstrative.
Arch.
As my understanding, he had a question, and I would respectfully ask that all questions come from her. So, are you done, sir? Or would you like more time?
No more time.
No objection. K 1 through 15 and K 17 will be admitted as demonstrative exhibits. And sir, I don't know if you'll be able to see from where you're seated, so if you need to step out into the what we call the well, you're welcome to do so.
Thank you, sir.
And permission to approach.
You may.
Dr. Confessor, I don't know how it'll show up on the screen, but here's a pointer.
Thank you.
Now, what is the investigatory process?
Okay, so the purpose of this investigation was to see if biomechanics could rule out suicide. That was the goal, eliminate the possibility of suicide. And so what you're seeing here in this first process flow, or the investigative process, is a published process in which to approach an investigation such as this. It was published by myself and a former professor of mine, Dr. Theodore Milner, in scientific forum. It's also been published several times in non-scientific forum, and it's dictated the process in which I followed to come to our conclusions. And so if we start with defined injuries, you'll see that it says from autopsy report, and that would be Dr. Howard's autopsy report with his cause of death, and relying on that. Moving forward, we're talking about defined dynamics. This wasn't captured by video. We do have witness statements from police officers as to her final resting place. We also have many scene photographs over several time periods, and we relied on that, especially her final resting place, as we'll get into in a minute. The analysis was based primarily on biomechanical modeling, as you'll see, but also a multitude of published literature and a full incident reconstruction of the event. We moved on to discuss how using these results were consistent with independent information, and then made our conclusion.
Okay. In your analysis of defined dynamics, were you able to observe any information from faro scans?
Yes, sir.
And can you explain what a faro scan is and how you relied on that faro scan?
Sure. A faro scan is a distance measurement machine on steroids, if you think of it that way. It's collecting many points per second, and it does that in 3 dimensions. and it gives you a three-dimensional representation of a scene that is accurate in dimensions. So we were able to understand the dimensions of the tub itself and then use that together with our biomechanical analysis of the known height and weight of Kendi.
Okay. And did your analysis in this case involve research?
I'd say there was a literature search that would assist, that would be helpful for you to understand. There was research on biomechanical modeling and an incident reconstruction of the event.
Did your research inform you as to any significance of intraoral gunshot wounds?
Yes, there was a paper, Schmidt or Kendar 2022 actually, that analyzed intraoral gunshot wounds and found that the trend was most of them were suicide.
Okay. Did you have an opportunity to review trajectory in this case?
I relied on Dr. Howard's interpretation of the trajectory. We also found photos from the autopsy useful in interpreting this, and also Dr. Nara's description of the trajectory was also helpful in the sense that it was horizontal to slightly downwards.
Okay. And did you examine the position of the body?
Yes. That was detailed carefully because we're working backwards from this moment in time with our biomechanical analysis. Specifically, we focused on the position of the arm, the orientation of the arm. What I mean by the orientation is hand up or hand down. And also the position and location, or I should say the position and orientation of the gun itself. So right-hand side of the body and the barrel pointing towards her head. That became important in our analysis.
Okay. What is, what did you look at as far as it relates to the firearm?
Well, we started there because that's the initial input to the hand as a system, as a mechanical system. And so we needed to know or understand the overall weight of the gun, where that weight is centered on that gun, the effect of its overall momentum. So we have a bullet that is published as being 90 grain in weight, moving at 1,040 feet per second. That gives us a momentum that occurs over 1 millisecond, and that gets the mechanical system moving, if you will. We also considered the slide movement and what effect that might have, either on the teeth or the hand itself, if it's being held with two hands. And then, of course, the trigger weight became very important. And what I mean by trigger weight is the amount of force you have to apply the trigger to actually discharge that firearm.
How did that become important to you?
Because there's lots of strength studies on index finger strength as well as thumb strength, and it changes depending on wrist angle. So ergonomically, there's a very specific way that you'd have to hold that firearm in order to match that trajectory and pull the trigger at the same time. What these studies are showing is that any wrist angle over 20 degrees is too much to be able to press 5 pounds with your index finger. And most of the positions were greater than that. In fact, they were closer to 60 degrees wrist flexion. And that actually allowed us to rule out the use of the index finger to discharge this weapon.
Now, we'll come to this again, I'm sure, but
sure.
You mentioned most of the positions. Can you describe what you're referring to there?
Sure. There was many considerations. One was the use of the left arm, but if that were the case, the gun would have ended up on the left-hand side of the body, so we were able to quite easily rule that out. again, the goal being to eliminate the possibility of suicide. Because the gun was found on the right-hand side, we focused on right hand and both hand scenarios. From there, we considered Kendi's stature with respect to the bathtub and what would be a natural position for her to be sitting there in. One is a sitting position and one is a reclining position, and then various positions from there, as you'll see in our results section.
Doctor, what is ergonomics?
It's the study of how humans interact with their environment. Specifically here, we're looking at strength requirements to perform a task. This task being depressing that trigger at least by 5 pounds. We are forced, that position is dictated by the trajectory and the positions and ranges of those joints. As I mentioned earlier, Lee 2002 found that any wrist postures flexion greater than 20 degrees was impossible. It was not possible to depress with your index finger a 5-pound trigger, so we were able to rule that out. However, in Imran 1991, looking at various pinch tasks, which is really measuring thumb strength, we were able to see that in various wrist positions, we would have enough force there to depress that trigger above 5 degrees. And so the focus became ruling out index finger positions and starting to focus on thumb trigger pull positions.
Now, what if the index finger is strong enough? Did you look at that?
Then it would actually increase the number of scenarios that would be consistent with suicide.
Okay. Did you examine the effect of recoil?
Yes, sir.
And can you kind of explain that?
Sure. So as I mentioned before, the transfer momentum from the gun to the hand applies a force to that hand. And the line of action of that hand, the line of action of that transfer momentum is along the barrel. That's what the assumption was. And it lies just above the hand itself. And so in that position then, the only thing that can happen with the wrist is supination. That's what this motion is here. And you can even just try it yourself by pushing on your first knuckle there. You'll cause an opening of your hand. And that became important to rule out many scenarios.
Okay. Did you have a chance to look at flexation? And, well, let me back up. What is joint axis and how did you test them?
Right. I think what this slide is getting at is the axes that were tested. So, for example, we limited it because the majority of the interaction with Kendi's arm after the discharge of the firearm would be gravity. We limited the axis of the shoulder into flexion extension, so in line with gravity. Did the exact same thing with the forearm, but the wrist we considered pronation, supination in isolation, i.e. it would be controlled by the input from the revolver. And then we also considered wrist flexion extension in our model. So those were the axes that we considered to move from a starting position to her final resting position.
Do you have any, how many scenarios did you examine?
We considered many, but we simulated 10.
Okay. And on that, when you say simulated, can you walk through what you mean by you simulated scenarios?
This is a mathematical model. It's not a graphic artist's rendition of what they believe to have occurred. This is physics driven, and so what you're seeing here, this is one of our scenarios results, and this is a situation where we had Kendi reclined and holding the firearm with two hands. And so what you're seeing here, the green line, is in fact the gun hand complex, okay? And you can see it slightly flexes, slightly extends as it moves throughout the motion. The first blue line represents the forearm, and the second blue line represents the upper arm. And it's important to note that the gun shape there is giving you the consequence of that model. So where does the barrel point when it gets to the bathtub floor? And is that associated with any supination? As I said before, so you can think of supination as holding some soup in your hand. It's open. In this case, that supination torque was actually canceled because we've considered both hands being on the firearm at the same time, and therefore the hand remains in a neutral position as it falls to the bathtub floor. But this would be a very typical simulation result, and we'll get into what those results mean in a table in just a moment, and what we've considered with each of them.
Did you look at or review any marks on Kendi's hands?
Yes. There was a linear laceration to her left hand, and in some cases, when you're not always aware of exactly where your fingers are in three-dimensional space and you discharge a firearm, you get what's called a slide bite. And so this linear cut could have been caused by slide bite.
Objection, lack of foundation calls for speculation.
Overruled.
Okay. Did this also serve to rule out other possibilities? Ms. Mark?
Again, the idea was to eliminate suicide as a possibility, and so we used this slide bite mark as a way to do that. So if we did away with the slide bite mark as being a possibility, then we'd actually add to the number of scenarios that would be consistent with suicide.
Okay. Now, did you put your, you said you considered many, but you modeled 10 scenarios?
Yes, sir.
And did you put that in any sort of visual representation?
The results we did.
Does this explain that?
It does.
And feel free to move about and explain it to the jury.
I was going to say, I think this would be a good time to do that. So just starting on the left-hand side here, what I'd like to explain is we started with overall gross body posture of Kendi's final position, and we considered both a sitting and a reclined version of that. Okay, so that's what the S and R mean.
And Doctor, real quick, just so you know, that is a touch screen, so.
Oh, I'm sorry. I'm bad with touch screens. I'm a Mac guy, but anyways, gun orientation. So this is the gun orientation at time of discharge. Okay, so we considered a vertical position as well as a horizontal position of the firearm. Went on to the hand, as I said earlier, we eliminated the left hand being involved because that would have caused the gun to be located on the left-hand side of the body, and that's pretty clear in the evidence that it didn't happen, so we did not consider it. But we did consider the both hand scenario, as I motioned to before. The trigger finger, we considered index finger as well as thumb discharge. And then how did these scenarios align with the evidence? So if we can just go through these one at a time. So here we have sitting, vertical, gun orientation, right hand index finger. We were able to eliminate this primarily based on trigger pull force, but also because it's single-handed, we would not have seen the slide bite. And so you can see every condition in which we consider the index finger has been eliminated based on that ergonomic data that I showed you earlier. Just going down one row, we see sitting posture, vertical gun orientation, right hand and thumb. And that is consistent with everything that we see documented at the scene, except for the slide bite. So as I mentioned earlier, if we get rid of the slide bite, we actually add scenarios that are consistent with suicide. So that's the approach here. And so if we look at trigger pull force, you can see we eliminated based on index force strength, based on arm position, for arm, upper arm that is, landed on the right hand side in the same position in all cases. The arm orientation, interestingly, in the sitting condition there was enough time, even though we had that supination occur at the discharge of the firearm, there was enough time that after her arm interacted with her thigh to settle into a more neutral position as found at the scene. Also interestingly, in the reclined position, there was very little time for the hand that was now supinated to make its way back into a neutral position after the elbow had touched the bottom of the tub. So in the reclining position, the elbow hit the bottom of the tub first, and then there was very little time for the forearm to correct itself, if you will. However, in the condition where both hands, I did it again, I'm sorry, where both hands are held on the gun, that doesn't actually happen, because when that firearm is discharged, it cancels the supination torque, keeping the right hand in a neutral position, allowing it to fall into the neutral position found at the scene.
Okay. So, in this also, did you have
Comment on the demonstration on blood in the bathtub. This would be very different in the court's view if this witness did opine that Ms. Howard committed suicide, or the evidence, the autopsy and so forth was consistent with her committing suicide and so forth. But this, in the court's view, this expert has limited his testimony solely to the biomechanics of what is possible biomechanically or engineering-wise in terms of how a gun can be held and so forth. So I think this is beyond scope and not proper. I guess the one thing I can see allowing a question simply to the extent that there were multiple other injuries that you didn't consider as part of your biomechanical review. But to show the witness additional autopsy photos and get his opinion on whether or not this was suicide or homicide, I think is significantly beyond the scope of this witness's testimony, and frankly, outside the purview of his expertise. So I'm going to grant the objection in limited, as I just indicated. Let's bring the jury. be seated. I sustain an objection. Mr. Rivera, you may continue.
Thank you, Judge. Sir, if you eliminated the possibility of Kendi being alive when she was shot, wouldn't you eliminate the possibility of suicide?
If I had evidence to show that, that would be true.
That would pretty much do it, wouldn't it?
If I had evidence to show that, yes.
All right. And so in terms of evidence, I assume your attorney that you work for gave you all the evidence in this case. Is that correct?
Yes, sir.
Because you wouldn't have come to the conclusion that you had otherwise, right?
I'm not sure what you're referring to, but I considered everything I received.
And so you considered the prior testimony and additional report of Dr. Ryan Rambaran, right?
Correct.
And his conclusion was that she was dead when she was shot. Do you remember that?
I do.
And you know that Dr. Rambaran has a medical degree?
Yes, sir.
Many years of experience as a trauma surgeon? Yes?
Objection outside the scope.
Sustained.
You considered the report of Dr. Smock?
Yes, sir.
Dr. Smock was very clear that she was dead when she was shot, right?
Objection outside the scope. Calls for her sake.
Sustaining based on my ruling previously.
Why, when you had these other pieces of evidence, this medical evidence, wouldn't you discount the possibility of suicide from the onset?
None of them actually were at the autopsy. I had an autopsy report from an equally qualified individual telling me that the cause of death was gunshot wound intraorally. And that's how I moved forward. A lot of the evidence that I had considered from those individuals I felt was primarily anecdotal.
Even though they had training and experience far in excess of yours?
In the medical area,
right.
Agreed, except there are many things that don't fit. For example, the amount of blood that was present. There was, I think, 2 individuals that testified in grand jury that there wasn't enough blood for this to have occurred when she's alive. But in fact, there's many factors that would prove that. I didn't say they prove it wrong, but I could prove it wrong in the sense that first of all, nobody's accounted for the amount of blood that was actually present, as far as I know. Number 2, we saw that the blood via test, which you don't need to be a doctor to assess, sunk to the bottom of the bathtub. Number 3, you've got blood that was lost during the draining between the hours of when Wheeler took his initial photographs and the coroner took his initial photographs. Further to that, Schmidt 1994 documented a very similar case where there was a witness suicide of intraoral gunshot wound that perforated the tongue and ended up in the upper cervical region, very similar to what we see here. And there was no aspiration of blood. There was very little blood found at the scene. And the conclusion of that paper, which was not by me, anyone can read that, was that there's a possible mechanism of reflex arrest when the spinal cord's involved. And so it stops the heart very quickly. And so taking all of that information in consideration, I think it casts doubt on that opinion.
On medical opinions. And you're
Testing can do that.
You're qualified to make that assessment?
Testing doesn't lie, as you saw. Those were my findings.
In your report you wrote on page 32, last part of the first paragraph, last sentence, furthermore, neither Mr. Livingston nor Dr. Rambaran offers an explanation as to where the missing blood might be found or how it disappeared. You remember that?
I do.
Okay. And you were provided with the transcript from the grand jury, right?
Portions of it.
And so you had that when you made that statement, right?
That's correct.
Let me show you that grand jury transcript of Dr. Rambaran. Direct your attention to page 559, line 23. And wasn't Dr. Rambaran asked the question, quote, okay, and so again, you know, the question remains, had the heart been pumping when this bullet went through the tongue, what would have been the result? And then what's his answer there on line 2, page 560?
It says again, significant and profound blood loss.
Why don't you take a moment, sir, and go through the rest of that particular page on that transcript and tell me whether or not Dr. Rambaran does explain where the blood would have gone. Had she been alive when she was shot?
He's testifying the fact that there would be in the order of half a liter to a liter of blood loss from that type of wound, which is inconsistent with the research that I cited, but I understand that's also a possibility.
So he talked about on line 22, page 560, the blood could only go 3 places, into the lungs, into the stomach, and into the environment, right?
Correct.
And then he talked about, on the next page, 561, about there being no blood in the lungs or the stomach, right?
Similar to the case study I quoted.
So
Yes, sir.
had to go into the environment, right?
No, sir.
That's what he testified to, right?
That's what he's testifying to.
Okay.
I've shown you.
You told us in your report he gave no explanation. I'm attempting to show you that he did give an explanation, okay?
He says into the environment, but we don't ever see that, is what I meant by that statement.
And because he drew the conclusion, because there is very little in the environment, that she was dead when she was shot, right?
Except we still don't know where the missing blood is.
Do you agree that his conclusion was that she was dead when she was shot?
That was his conclusion, correct?
And so when you wrote that he gave no conclusion in your report, that was incorrect, wasn't it?
I think you're mischaracterizing what I said.
Didn't you say, furthermore, neither Mr. Livingston nor Dr. Rambaran offers an explanation as to where the missing blood might be found or how it disappeared?
Right.
And isn't his explanation that she was dead when she was shot?
Except it still doesn't account for where that blood actually is.
It would be in her body, sir, would it not?
Except there's blood in the water.
Yeah, there's very little blood in the water, isn't there?
Nobody knows that.
Don't you think a medical doctor can make such an assessment?
I think a test is worth 1,000 expert opinions.
Don't you think a medical doctor has extensive training in terms of determining how the heart works?
Of course, I'm not judging that. I'm just going by the literature I cited.
Okay. You wrote on that same paragraph a little bit further up, given that gunshot injury involved transection of the spinal cord at the C2 level, it would have cut off brainstem regulation of the respiratory and cardiovascular systems. Remember that?
I do.
And is that accurate by your account?
It's also, yes, and it's also consistent with the research that I cited. I speak specifically to the regulation of the heart rate. So blood pressure can go up, blood pressure can go down, or the other option that was given by the research I cited was that it can also stop the heart.
Are you familiar with the medical concept that the heart runs on a different nervous system than the lungs?
Yes, it can continue beating.
All right, and so that bullet transection at C2 wouldn't necessarily stop her heart, would it?
Not necessarily, no.
Okay, so her heart could have kept pumping, right?
That's true.
And so your statement's not correct, right?
No, you're mischaracterizing what I'm saying.
You said it would cut off brainstem regulation of the respiratory and cardiovascular systems, right?
Regulation, so sympathetic, parasympathetic, things of that nature. But I would defer to Dr. Howard's autopsy opinion about that. I would also defer to the research that I've cited.
Okay, so her heart would have kept pumping had she sustained that bullet wound. Is that what you're saying?
Not necessarily, no. And I've shown how that is possible.
Because of that study?
Correct.
Do you remember what that study was? What the name of it was?
It was Schmidt, 1994, case study number 3.
Let me approach it. I think I have the right study. All right? Take a look at it. Tell me if you recognize it.
Sure. I recognize it.
Is that the one?
I'm referring to.
Is that the one you're talking about?
Yes, sir.
In this case, what you're focusing on is the person that shot themselves.
That was witnessed and had no aspiration into the lungs similar to this, and there's a little blood found in the scene. And the authors on page 59 conclude there is no doubt that contusion of the cervical spinal cord can cause reflex heart arrest. And that's what I'm specifically referring to.
Now, what I wanted to ask you about with that particular study, I'll find where I am here. Let me pull from the book. All right, there we go. Recognize that?
I do.
That's your K3. Your exhibit K3.
Yes, sir.
What is it?
It's just a rendition of Dr. Howard's description of the wound path.
Okay, and what's your description of the path?
Perforated the tongue, ended up fracturing C2 and transection, and transecting the spinal cord at that same level.
So to transect the C2, is it going down or up?
It was described as being horizontal or slightly down by Dr. Nara.
Well, I'm asking for your opinion as you sit there and look at that line today. Is that going horizontally or is it going down?
Clearly it's going down.
Okay. And so you would describe the trajectory of the bullet that went through Kenny's mouth as downward?
I didn't analyze the trajectory, but we're, referring to Dr. Howard's report, that's...
Do you think you could analyze that for us and tell us what your conclusion is in terms of the trajectory?
It's perforating the tongue and transecting near C2.
Is it going down or not, sir?
Of course it's going down. Yes, sir.
All right. Where's the soft palate?
Soft palate is upper region here.
Can you show us?
Right there.
All right. And so the study that you relied on with the person that shot themselves in front of a witness, didn't they shoot themselves through the soft palate?
It was intraorally and it was upper surgical, but upper cervical region is where the bullet ended up. Similar to this, it did transect the tongue, but I agreed with you that there was some differences.
So this one study that you've relied on, there was a completely different trajectory, wasn't there?
It wasn't completely different. It was intraoral, it transected the tongue, and the bullet ended up in the upper cervical region, similar to this case.
It was different in that that bullet went up, whereas the bullet in our case went down, right?
It wasn't described that way.
Okay. If you read the journal entry, if you read the facts, you know that the bullet went through the tongue and into the soft palate, right?
I believe that's what it said, yes.
One can make a pretty good inference that that shot is going up if it's going into the soft palate, as you've just showed us, correct?
There's different regions of the soft palate, though. I mean, the main one is here, but also back here before it turns into the pharynx.
So you can't agree that this other study, the trajectory was going up?
It's not detailed to that level, so I can't know.
Wouldn't that make a difference if it was going up, in your mind?
It still details that it was upper cervical region, so we're looking at more horizontal, possibly slightly upward trajectory in this particular case file, yes.
In that study, it didn't even go through the C2, did it?
It says upper cervical region.
So you don't even know where the bullet landed in this other study, right?
It's upper cervical region, is what they say.
And I guess what you're doing is you're basing this conclusion that her heart would have stopped based on a study that isn't really applicable to our case, right?
I disagree with that statement.
Okay, even though we have these differences?
There's slight differences.
Okay. In that particular study, I think you still have it in front of you. On page 57, it indicated a very low percentage rate of handgun injuries that involve the neck region. What was it, 2% there under discussion, number 3? Is that right? According to the study that you referenced.
You're referring to the sentence that says only a few suicides shoot themselves in the neck?
Actually, I was going to get to that one next. I was looking at about 2% of handgun injuries involve the neck region. It's a little bit above that.
Right, I do see that.
Do you agree with that?
That's what they state, but I'm assuming that's external.
Okay. Well, what about that next line there? Only a few suicides shoot themselves in the neck. 1.5 to 4% of firearm injuries in this location may be attributed to self-infliction, while the vast majority, as in cases 1 and 2, are homicidal. You agree with that?
I'm not sure what line you're on.
Go down about 5 lines. So we're still under discussion on page 57. It starts off, as you noted earlier, only a few suicides shoot themselves in the neck.
I see. And then it continues saying 1.5 to 4% of firearm injuries in this location may be attributed to self-infliction. Except I believe in that case they're talking about external gunshots to the neck, not intraoral.
What's the last part of the sentence?
Well, the vast majority, as in cases 1 and 2, are homicidal.
You agree with that?
That's what they state.
Well, you relied on the study for another fact, right?
What's that?
That her heart could have stopped based on that shot.
You mentioned that there's a reflex mechanism for that, yes.
Yeah, so I'm asking you if you are good with this as well.
I would be, yes.
Okay. You relied on another study. I think, oh, sorry about that. Autopsy features relevant for discrimination between suicidal and homicidal gunshot injuries.
Is that Carger 2022? Sure. Yeah, that's Carger.
I think you quoted some parts of that article. Is that accurate?
I didn't cite them as accurate. I mean, if they're published, the scientific community has accepted it. What I was drawing some attention to is the trend of intraoral gunshot deaths are primarily suicidal.
Okay. What I wanted to ask you about is on the first page under abstract. It's kind of near the end on the left side. And quote, it says, from 61 suicides who fired the gun inside their mouth, only 1 pointed the gun downwards. Consequently, some bullet path directions cannot be considered indicative of suicide. Downwards and back to front in gunshots to the temple, left to right in gunshots to the left chest, and downwards in mouth shots. You remember reading that?
Yes.
When you cited to this article in your report?
That's also in our report.
Do you agree with it?
I can't deny it, no.
Okay.
I believe the statistic was 95% are homicide and 5% are suicide. So you still can't rule it out, is the point.
Okay. And in our point here, when you've got a downward trajectory in terms of the gunshot wound to Kindy, it's indicative of homicide, is it not?
According to that literature, it is.
That you cited to.
Correct.
Take a look at page 276. Under direction of the bullet path, it says, quote, the direction of the internal bullet path may differ between suicides and homicides for a particular entrance wound site. Suicides commonly intend to have a stable and comfortable position of the shooting hand and a fatal effect of the gunshot. Remember reading that?
I don't actually, but you've refreshed my memory.
Do you agree with it?
If that's what they're saying, can we just go to that part one more time? I didn't get a chance to read along with you.
You want me to read it again?
I'd like to read it myself.
Oh, take your time.
Okay. And it's 276?
Yeah, it's under direction of the bullet path. You want me to point it out to you?
Oh, there it is. I see it. So you've read the first paragraph? Is that what you're referring to?
Not the whole paragraph, just the first couple of sentences.
Yeah, those are the trends, yes.
And so that last part is what I kind of wanted to focus on. For someone to get a comfortable spot in order to shoot themselves, you'd agree with that assessment in that particular article you cited to?
Typically, things are done ergonomically, yes.
All right. All right, let me show you some photographs, I think. You probably got some of them in through your attorney. I'll run through things real quick. Recognize 100?
I do.
What do you recognize that to be?
The two conditions of the firearm at discharge that we considered, so horizontal being A and vertical being B.
101.
That's horizontal. It's one of the positions we considered.
102.
Another position we considered.
And then the last one, 103.
Yes.
Same thing.
Yes, sir.
All right. Those are accurate photographs and images from your report?
Yes, sir.
Move to admit 100 to 103.
Any objection?
For demonstrative only.
You may, I'll admit them as demonstrative.
Okay, so looking at 100 here of one of your images, one of the problems I think you told us about with this not being able to be consistent with Kendi shooting herself is it the angle of the wrist? Is that accurate?
Correct. We found that in that wrist position, according to strength tables, she would be unable to depress the trigger.
There's another problem with either of those two examples too, isn't there? A big problem.
What's that?
Trajectory.
And these are demonstratives. It's just showing index finger versus index finger, yeah, in the two positions. But it's important to understand that this is based on Blender model, and that is a characterization or a representation, not the actual angles that were used.
The trajectory doesn't work here, does it?
Sorry?
The trajectory does not work here with these images, does it?
With these images, they could be made to work, but these were probably performed early on when we were putting the report together. But I assure you, there's lots of other examples where the trajectory is correct and considering these positions. But I've already stated that the index finger is not a condition that would work in this particular case.
Right. Nor would this trajectory.
Correct.
Okay. And then looking at 101, does that get you to the necessary trajectory in our case?
It would be close. Appears to be close, yes.
But that doesn't really look like a comfortable way in which someone would shoot themselves, does it?
Agreed.
It's a little odd, isn't it?
It is, but it was a consideration.
It's not really how she was positioned in the bathtub either, right?
Not her final resting point, no.
And so that just isn't accurate at all, is it?
I disagree. I think this is a possible scenario. The tub itself is modeled accurately, placed the feet and the buttocks close to where they were found at rest, and then obviously if this was a position, she would settle into the reclining position she was found in. That was the idea.
Kind of the same thing, but you've reclined her as opposed to the previous photograph here in 102?
Correct.
All right. Do you think that gets us to the necessary trajectory?
It's close.
It's still got a little bit of a problem with being comfortable, right?
Agreed.
Okay. And then I think what you ultimately thought was your best method of showing that Kendi shot herself was 103. Is that accurate?
That's the scenario in which both hands are being held, and yes, that's the most likely scenario, the ones we've tested.
How long is that slide on the gun? I think you put it in your report. It was like a little over 5 inches, right?
Something like that, yes.
How long is her hand? You got that in your report too, right?
I don't recall.
Let me track that down. Hold on. turn to page 37 of your report. Let me know when you get there.
I don't have a copy of my report, so
Oh, you
I
don't?
have a copy.
Yeah. Thank you.
Thank you.
All right, everyone please be seated. All right, defense, call your witness.
Defense calls Dr. Veronica Zamora Campos.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you will provide will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand. This witness is appearing by Zoom. State any objections to the witness appearing by Zoom.
No, Judge.
Defense, any objections to the witness appearing by Zoom?
No, Your Honor.
Mr. Ruiz, do you have any objection to this witness appearing by Zoom?
No.
All right, if you'll state your name for the record, please.
Dr. Veronica Zamora Campos.
All right, defense is your witness, and please make sure, everyone, that you speak into the microphones.
Doctor, you are a pediatrician, right?
Yes, that's correct.
And are you a member of a practice?
Yes, I am.
How many doctors are there?
We have 4 providers.
Currently, when did you first treat Mercedes Lasoya?
I treated Mercedes on September 21, 2017.
Were you the first person to treat her?
That is correct.
And after that time, did you treat her or were other doctors in your practice treating her?
The other providers treated her.
If you were to treat Mercedes today, and you can't because she's dead, but if you were, would you be referring to those records before you dealt with the child?
Yes, yes, I would.
Okay. Is that a common practice?
To refer to the record when we treat our patients? Yes.
Yes. Okay. Did your records indicate that there were appointments that the child did not show up for?
Yes.
Can you tell us which dates the child did not show up for appointments?
May 3rd, 2018. September 5th. No, correction. That's an error. November 15th, 2018. March 5th, 2019. July 9th, 2019. April 27th, 2020. August 11th, 2020. March 10th, 2021. And July 23rd, 2021.
Okay. Do your records indicate why the child did not show up?
I'm gonna object. Calls for speculation and hearsay.
All right, if you know, you can answer the question.
No indication. No indication on the record why they did not show up.
Thank you. Do you have a diagnosis in your records for the disease of asthma?
Yes.
And does it notice in your records when the child was first diagnosed with asthma?
Her mother's history, August of 2017.
2017. So, what was the regime that was recommended to the parent to care for the child with asthma?
In which visit?
Whenever. The first time, whenever she first got instructions on how to deal with the disease.
According to her I believe it was her March 28, 2018 visit. that she received instructions on wheezing, and her medications were initiated. So just can't speak for the physician what they spoke verbally, but they gave her guidance on when to follow up in 1 month.
Did she show up for that visit in 1 month?
No, but she was rescheduled. She was rescheduled like 3 weeks later, 26 days to be exact.
Did she show up for that appointment?
Yes, she did. She did show up at that visit, and then, but she usually had another reason for coming in. Hers was a hand, foot, mouth. She had gone to, one moment. Oh, she'd gone to the ER. She had gone to Baptist ER for a rash. And that's when they gave her a breathing treatment. So, yeah, they discussed it at those 2 visits.
What kind of medications were prescribed, if any?
Albuterol, which is a bronchodilator, that was an inhaler, and Flovent, which is an inhaled corticosteroid, as a preventative measure for asthma flare-ups.
Do you know if those prescriptions were filled?
No, I do not.
There is, if a child holds her breath with this condition, would that be a voluntary thing more than likely, or?
I'm gonna object, calls for speculation.
All right, you're going to ask your question, then the court will hear your objection.
Repeat the question?
If a child were to hold her breath with this condition, would it be a result of asthma or just bad temper or what? Can you say?
Unlikely for a 2-year-old to hold her breath willingly.
Are there any other specific maladies that Mercedes was diagnosed with?
Oh, when I saw her specifically, it was just her speech delay. That's throughout all her 7 provider visits. Most of them are well checked. Most of them are about her speech delays and getting referred out for early childhood intervention, speech therapy.
I noticed she missed an appointment in March of the following year when she'd have been 1-year-old. Up to that point, did she have all her appropriate vaccinations and shots?
I'm gonna object. I'm sorry, doctor. I'm gonna object to relevance.
Sustain.
There's a diagnosis down there and not so much a diagnosis, but a recommendation that she receive cardiovascular care. Which doctor recommended that?
Dr. Sedlick. That was her last visit in the office, April 23rd, 2021.
Is there any indication that she followed up on that with a cardiologist?
We do not have records, but it's not uncommon for us not to receive the records from the specialist.
Did Dr. Settler describe why she was recommending cardiology treatment for
Because she heard a heart murmur on exam.
What does that really mean?
There's an extra sound between your heartbeats. So like lub-dub, you're gonna have a sound in between or after. So it's an extra sound that we hear, and we investigate it. Majority of them are benign, but as a rule, we try to be complete and refer to cardiology just to rule out any other problem.
You have no further information on your file, is that correct?
That is correct.
Yes, the witness.
State has no questions.
All right, is this witness excused?
Yes, Your Honor.
Yes, Judge.
All right, the rule has been invoked. What that means is you cannot discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state of the defense. Do you understand?
Yes, I do.
All right, thank you. You're excused.
Thank you.
Defense, call your next witness.
Rest and close, Your Honor.
All right, state, do you close?
State rest and close, yes, Judge.
All right, and defense, you close.
Yes, Your Honor, rest and close.
All right. All right, so ladies and gentlemen, this is all the evidence you're going to hear at this phase of the trial. What I'm going to do is I'm going to send you to the back. We still have a couple more things to work on the jury charge, and then I'll bring you back. Remember my previous instructions. All right, everyone, please rise for the jurors.
Honorable Court of Common Pleas is now open pursuant to adjournment. The Honorable Judge Brendan J. Sheehan.
Thank you. You may be seated. Okay, good morning. We're here today on the state of Ohio versus Crystal Candelario. That's you, Ms. Candelario. This is case number 23-682-241. Representing you, Ms. Candelaria, is Mr. Derek Smith and Mr. P.J. Mulligan. Representing the state of Ohio is Ms. Anna Ferelia and Ms. Jordan Mason. Before we start, we've had numerous pre-trials on this matter, and we have an interpreter here that's been involved in all the proceedings. And Robert is here. Robert, do you want to stand up? Robert, you've been involved with the court. Your training and credentials as an interpreter has been reviewed by this court. And you are familiar with the National Association for Judiciary Interpreters and Translators, the Code of Ethics and Professional Responsibility, and you've interpreted here many times in this court. Robert, I want you understand that you are to be a neutral party who is here to facilitate communication, and that you should not offer advice or interject your opinion into these proceedings. You understand that? Yes, Your Honor.
All right. So with that, is there any objection to Robert being the interpreter for this hearing?
Not on behalf of the state, Your Honor.
No, Your Honor.
All right. So Robert, you want to raise your right hand? You do solemnly swear that you will interpret accurately, completely, and impartially, using the best skill and judgment in accordance with the standards prescribed by law, and follow the official guidelines established by this court for legal interpreting or translating, and discharge all of the solemn duties and obligations of legal interpretation and translations as you shall answer unto God. Please say I do.
I do.
Thank you, Robert. All right. All right. So we're here today for a sentencing hearing. Ms. Candelaria, on February the 22nd, you pled guilty to count 1, which is titled aggravated murder, an unclassified felony, which is potential sentence of life with parole eligibility after 20 years, life with parole eligibility after 25 years, life with parole eligibility after 30 years, or life without parole. You also pled guilty to count 5, endangering children, which is a felony of the 2nd degree, which is punishable by 2 to 8 years and or a $15,000 fine. And there's also the Reagan-Tokes advisements I advised you of, which is whatever sentence this court imposes on count 5 must be served 50% of that number. So we went through that at the plea, so you understand that. At that time of the plea, we requested a pre-sentence investigation report. We received a report from Michael Rahm, R-A-H-M, on February the 28th. I shared it with both the state and the defense. Ms. Ferelia, Mr. Smith, have you had a chance to review this report?
I have, Your Honor.
Yes, we have.
Any additions or corrections to this report by either party?
No, Your Honor.
No, Your Honor.
I also have received sentencing memorandums and mitigation reports from the defense by Mr. Smith and Mr. Milligan, and I also received a state sentencing memorandum by Ms. Ferelia. With that being said, is there any additions or corrections that this court needs to review?
With regards to the briefs, no, Your Honor.
The briefs, yes.
No, Your Honor.
Ms. Candelaria, are you ready to proceed to sentencing?
Yes, Your
That being said, this is the procedure we're going to follow. I'm going to turn to the state first. Ms. Freya, you'll put on your sentencing hearing and allow you to present evidence and victim impact statements. And then when I hear from the state and all the state's representatives, I'll turn to the defense. I'll hear from you, Mr. Smith, and anyone who wishes to speak on behalf of Ms. Candelaria. And then I'll hear from you, Ms. Candelaria, and then I'll impose my sentence, okay? That's how we're going to operate. So with that being said, Ms. Freya, are you ready to proceed?
I am, Your Honor. Thank you. Good morning, Your Honor. We're here on a very tragic case. The state of Ohio has prepared a PowerPoint presentation because the state wants you, when you impose your sentence, that you look at Crystal Candelaria's actions. And anybody that knows me or has been in this courthouse would know that I talk about actions in all my cases, because as adults, we are responsible for our actions and there are consequences to our actions. So let us begin on this fateful day that Jaylene Candelaria lost her life. If in fact we would have gone to trial, the evidence was going to show that Crystal Candelaria left the state of Ohio on 6/4/2023. She leaves because there is a receipt that's found in her car that she is in Taylor, Michigan. Unbeknownst to Ms. Candelaria, her neighbors had Ring doorbell, and the Cleveland Police Department Homicide Unit has gone through 648 hours and videos of the Ring doorbell, which you're going to see in this presentation. With regards to Ms. Candelaria, she returns to Cuyahoga County on 6/6 at 7:41 a.m. So at this particular point, we have reason to believe that this child was left alone for 2 days now, and she returns on 6/6/2023. Additional cameras show her again at 11:51 on 6/6 and on 5/24 of 6/6. She is taking a suitcase and now leaving Cuyahoga County. We have a map and a flock camera which shows her on, I believe it's Lafayette and Charter, northbound, at 6/6 at 20:05, which is 8:05 p.m., and that's a flock camera. Through the search warrants, we were able to retrieve her Spirit airline tickets that showed her departure and her return from Puerto Rico. She was gone from 6/8 to 6/11. And it's interesting, Your Honor, because in the defense memorandum, it says that her abrupt stopping of medications played a significant role in her ability to function as a parent and make sound decisions. So when we look at, these are items from her phone, her actions indicate to us that she is in Puerto Rico having a good time with friends, and that there is not a care in the world about the 16-month-old that was left alone in the pack and play. These pictures show somebody who is showing sound discretion and judgment because she's having a good time. Meanwhile, this child is in a pack and play. She returns to Detroit, and while she is in Puerto Rico, the detectives were able to locate on the Ring doorbell that on 6/9/2023 at around 1:04 a.m. in the morning that you hear this child crying. So now we have Miss Candelaria's car. She's returned from from Puerto Rico back to Michigan, where she was with one fellow and then traveled to go see another fellow traveled to Imlay, Michigan to be with another fellow. So that's from 6/12 to 6/15. Her car is found on all these flock cameras. Not once is she returning to Cuyahoga County. Now we turn our attention to June 16th at 7:36 a.m. She is back in Cuyahoga County. Her car reappears in front of her house. She goes in and she finds her daughter dead. She takes the time to redress her, and then she calls 911.
Friday, June 16, 2023, 07:47 and 26 seconds. Please release dispatcher telephone, union police, fire, EMS. Police, union police, fire, EMS. What's the address? We want 29, 197. 129, 3129 West Please, I need help. Okay, I can't help you if I don't know where you're at, so tell me the address so we can help you. 3129 West 97. Okay, is it a single or an apartment? Please. What's your name? Crystal. What's your last name, Crystal? Crystal Candelaria, please help me. And what's your number in case you get the Tell me what's going on. What's going on? Okay, now, let me give you a calm down. I need you to tell me what happened. Okay, I'm gonna give you a few moments to calm down. Crystal. Please listen to me so I can help you. She don't respond. She's white. She's white. She's white. You can't hear her, but it's just 6:30. I can't speak English. I'm understanding you. Tell me who's white. Who's white? Please. Your mom? Is that your mom? I am mom, yes. I am mom. Do you live here? My daughter is dying. My daughter is dying. Oh, your mother is dying? She's dying. She's dying. I'm going to look at post office. Please, I need help. How old is she? She's almost 15 months. Please help me. Okay, I'm going to get you over to my oh my goodness. That's where we're supposed to be, okay? Oh, my name is dying. Oh, I need it, Mother.
And then she's so overwrought with emotion on June 17th that she picks up and goes back to Michigan to meet up, not with the guy that she had gone to Puerto Rico with, but the other guy that she was seeing. And in her house during a search warrant, there was found this notebook that had written harm from neglect. This is the location where Jaylene was housed for 10 days without anybody being present, any adult, in a 3x2 pack and play with maybe a bottle or two of milk and maybe some crackers. And the mattress that was found was urine laden and feces strewn throughout the pack and play. Now, this is where it begins, Your Honor. I come from an Italian Catholic family, and both my parents were immigrants and they spoke broken English. And we have this good interpreter that has been with us during this whole case. This is the very first interview, the crying of the 911, and this is the first interview that she has with a detective from homicide. Again, pay attention to her actions and how she speaks to this detective.
But in the last week, she get a vomiting too. Remember right now when you mentioned the vomiting. She get a vomiting the last week, Monday and Tuesday, 2 times. But I was trying controlling because I know I give to her Tylenol or something, you know, for controlling the vomiting.
Okay. Come on, sir. This is my supervisor, Sergeant Gomez.
Too. I give to her when she got a diarrhea or vomiting. Hola, ¿qué tal?
Soy la secretaria por el departamento de
Well, just to take note, Your Honor, she's
so yeah, that's the situation, and after that, she was refusing to do the food, and she was with no appetite. I say, oh my God.
This is after last Monday and Tuesday when she was throwing up?
Yeah. Mm-hmm.
Okay.
Yes.
Are you talking about Monday and Tuesday like 4 days ago?
Yeah,
okay.
The last week, yes.
Okay.
Yes. Because we're almost done this week, so I talk about,
Because what, this week?
This week. Yeah, I talk about because we're almost done, you know.
Oh, we're almost done with this week.
Yeah.
Okay. All right, so that was just Monday and Tuesday of this week. She was throwing up.
Yes.
And then how was she Wednesday and Thursday?
She was with no food, just with a meal because she was refusing. Maybe it's because she get a vomiting 2 days, before.
Yeah.
So that's why it was scary because I say, oh my God, maybe go to the hospital because she doesn't eat anything, and she was lose tiny, her weight. I lose, her weight. But right now, this morning when I wake up, she was asleep. She sleep every day 12 hours.
Okay.
She sleep like at 9 p.m. through 9 or 10 a.m.
Okay.
12 hours. So in this morning I was sleeping too. I never wake up. She was.
What happened? What was going on last night?
Last night she was crying a lot, and I see one moment when I was take a shower, and she was screaming like I don't know, probably she get a pain.
Okay.
Maybe.
About what time was that last night?
Maybe at 7 or 8 p.m.
Okay.
So she was screaming like, probably for pain or something like that. In this morning when I wake up, I took her in the morning for, JD, wake up, and she wake up, and when I see her, I see she looks like a really, really dry, like a, ¿cómo se dice cuando una persona se chupa, o sea, kind of like, yeah.
Oh, like her face was sunken in?
So, ahí fue que yo me asusté y dije,
And then she is then brought into homicide. She's arrested.
In count 2 of the indictment with the offense of aggravated assault with a deadly weapon alleged to have been committed on or about the 28th day of January 2022 in Bexar County, Texas. The defendant, Jose Ruiz, is charged in count 3 of the indictment with the offense of injury to a child alleged to have been committed on or about the 21st day of January 2020 in Bexar County, Texas. The defendant, Jose Ruiz, is charged in count 4 of the indictment with the offense of injury to a child alleged to have been committed on or about the 23rd day of January 2022 in Bexar County, Texas. Deputy Laura. The defendant, Jose Ruiz, is charged in count 5 of the indictment with the offense of injury to a child alleged to have been committed on or about the first day of February 2022 in Bexar County, Texas. The defendant, Jose Ruiz, is charged in count 6 of the indictment with the offense of injury to a child alleged to have been committed on or about the second day of February 2022 in Bexar County, Texas. The defendant, Jose Ruiz, is charged in count 7 of the indictment with the offense of injury to a child alleged to have been committed on or about the third day of February 2022 in Bexar County, Texas. The defendant, Jose Ruiz, is charged in count 8 of the indictment with the offense of injury to a child alleged to have been committed on or about the 5th day of February 2022 in Bexar County, Texas. To all of these offenses, the defendant has pleaded not guilty. 1. Our law provides that a person commits the offense of injury to a child if the person intentionally, knowingly, or recklessly, by act or by omission, causes to a child 1. Serious bodily injury, or 2. Bodily injury. 2. An omission that causes serious bodily injury to a child is conduct constituting the offense of injury to a child if the actor has assumed care, custody, or control of the child. For purposes of an omission that causes serious bodily injury to a child, the actor has assumed care, custody, or control if the actor has by act, words, or course of conduct acted so as to cause a reasonable person to conclude that the actor has accepted responsibility for protection, food, shelter, or medical care for a child. 3. A person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault with a deadly weapon if the person commits an assault, as defined above, and the person uses or exhibits a deadly weapon during the commission of the assault. 4. Child means a person 14 years of age or younger. Act means a bodily movement, whether voluntary or involuntary, and includes speech. Omission means failure to act. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 6. The phrase on or about means that the state is not required to prove that the alleged offense happened on that exact date, but the date of the offense alleged in the indictment must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by the statute of limitations. The statutory limitation period for the offense of injury to a child is 10 years from the 18th birthday of the victim of the offense. The statutory limitation period for the offense of aggravated assault is 2 years. The indictment in this case was filed on May 3, 2022. 7. Our law provides a person is criminally responsible as a party to an offense if the offense is committed by his own conduct or by the conduct of another for which he is criminally responsible, or by both. A person is criminally responsible for an offense committed by the conduct of another if acting with intent to promote or assist the commission of the offense he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. Each party to an offense may be charged with commitments. Mere presence alone will not make a person a party to an offense. 8. You are instructed that an accomplice witness, as the term is hereinafter used, means any person connected with the crime charged as a party thereto, and includes all persons who are connected with the crime as such parties by unlawful act or omission on their part, transpiring either before or during the time of the commission of the offense, and whether or not they were present and participated in the commission of the crime. You are instructed that a conviction cannot be had upon the testimony of an accomplice witness unless the jury first believes that the accomplice witness's testimony is true and that it shows the defendant is guilty of the offense charged against him. And even then, you cannot convict the defendant unless the accomplice witness's testimony is corroborated by other evidence tending to connect the defendant with the offense charged. Such corroboration is not sufficient if it merely shows the commission of the offense. It must tend to connect the defendant with its commission. The witness, Katrina Mendoza, is an accomplice as a matter of law if any offense or offenses was or were committed, and you are so instructed that you shall consider her as such and treat Katrina Mendoza as an accomplice. Therefore, you are instructed that you cannot convict the defendant, Jose Ruiz, on the testimony of Katrina Mendoza alone. You are instructed that the testimony of Katrina Mendoza must be corroborated by other evidence tending to connect the defendant with the offense committed. Moreover, you cannot convict the defendant upon the testimony of Katrina Mendoza unless you first believe that the portion of her testimony that ascribes guilt to the defendant is true and shows that the defendant is guilty as charged in the indictment, and then, as stated above, you cannot convict the defendant upon said testimony unless you further believe that there is other evidence in the case outside of the evidence of the said accomplice tending to connect the defendant with the offense committed. If you find that an offense was committed and the corroboration is not sufficient if it merely shows the commission of the offense, but it must tend to connect the defendant with its commission, and then from all of the evidence you must believe beyond a reasonable doubt that the defendant is guilty of the offense charged against him. You are further instructed that you are required to agree unanimously on the evidence that you believe corroborates the testimony of Katrina Mendoza. You are further instructed that the state must prove the corroborating evidence beyond a reasonable doubt, and if they fail to do so, then you cannot consider that evidence as corroborating. 9. A person is criminally responsible if the result would not have occurred but for his conduct operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the actor clearly insufficient. Therefore, as to each count, you cannot find the defendant Jose Ruiz guilty unless you believe beyond a reasonable doubt that the injuries, if any, sustained by Mercedes Lozoya, if they were, would not have occurred but for the conduct of Jose Ruiz, either acting alone or together as a party with Katrina Mendoza. So that if you believe that the conduct of another person or persons alone was a concurrent cause sufficient to cause the alleged injuries sustained by Mercedes Lozoya, and the conduct of Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, was clearly insufficient, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. 10. It is a defense to the prosecution for the offense of injury to a child that the act or omission consisted of emergency medical care administered in good faith and with reasonable care by a person not licensed in the healing arts. Therefore, with regards to the allegations in paragraph A of count 1, even if you unanimously find that the state has proven beyond a reasonable doubt that Jose Ruiz did intentionally or knowingly cause serious bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by a manner and means unknown to the grand jury, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, Jose Ruiz was administering emergency medical care in good faith and with reasonable care, then you will find in favor of Jose Ruiz on this defense. However, with regards to the allegations in paragraph A of count 1, if you unanimously find that the state has proven beyond a reasonable doubt that Jose Ruiz did intentionally or knowingly cause serious bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by a manner and means unknown to the grand jury, and you further find from the evidence beyond a reasonable doubt that at the time he did so, Jose Ruiz was not administering emergency medical care in good faith and with reasonable care, then you will find against Jose Ruiz on this defense. With regards to the allegations in count 3, even if you unanimously find that the state has proven beyond a reasonable doubt that Jose Ruiz did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with the hand of Jose Ruiz, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, Jose Ruiz was administering emergency medical care in good faith and with reasonable care, then you will find in favor of Jose Ruiz on this defense under count 3. However, with regards to the allegations in count 3, if you unanimously find that the state has proven beyond a reasonable doubt that Jose Ruiz did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with the hand of Jose Ruiz, and you further find from the evidence beyond a reasonable doubt that at the time he did so, Jose Ruiz was not administering emergency medical care in good faith and with reasonable care, then you will find against Jose Ruiz on this defense under count 3. 11, count 1, paragraph A. If you believe from the evidence beyond a reasonable doubt that on or about the 7th day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause serious bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger by a manner and means unknown to the grand jury, and you find beyond a reasonable doubt that the defense of reasonable emergency medical care as instructed in paragraph 10 does not apply, or paragraph B, if you believe from the evidence beyond a reasonable doubt that on or about the 7th day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by omission cause serious bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, and Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, had assumed care, custody, or control of Mercedes Lozoya and failed to do so, and that Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, failed to seek adequate medical treatment for Mercedes Lozoya, then you will find the defendant, Jose Ruiz, guilty of the offense of injury to a child as charged in count 1 of the indictment, and do not consider paragraph 12. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 1 of the indictment, say by your verdict not guilty of the charged offense of injury to a child in count 1, and next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 1 as instructed in paragraph 12. 12. Count 1, lesser included offense, paragraph A. If you believe from the evidence beyond a reasonable doubt that on or about the 7th day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did recklessly by act cause serious bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger by a manner and means unknown to the grand jury, and you find beyond a reasonable doubt that the defense of reasonable emergency medical care as instructed in paragraph 10 does not apply, or paragraph B, if you believe from the evidence beyond a reasonable doubt that on or about the 7th day of February 2022 in Bexar County, Texas, the defendant Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did recklessly by omission cause serious bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, and Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, had assumed care, custody, or control of Mercedes Lozoya and failed to do so, and that Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, failed to seek adequate medical treatment for Mercedes Lozoya, then you will find the defendant Jose Ruiz guilty of the lesser included offense of reckless injury to a child in count 1. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant Jose Ruiz not guilty of the lesser included offense of reckless injury to a child in count 1. 13. Count 2. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 28th day of January 2022 in Bexar County, Texas, the defendant Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did use or exhibit a deadly weapon, namely his hand, that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally, knowingly, or recklessly cause bodily injury to Mercedes Lozoya by covering the mouth and nose of Mercedes Lozoya with the hand of Jose Ruiz, then you will find the defendant Jose Ruiz guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant Jose Ruiz not guilty of the offense of aggravated assault with a deadly weapon as charged in count 2 of the indictment. 14. Count 3. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 21st day of January 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with the hand of Jose Ruiz, and you find beyond a reasonable doubt that the defense of reasonable emergency medical care as instructed in paragraph 10 does not apply, then you will find the defendant Jose Ruiz guilty of the offense of injury to a child as charged in count 3 of the indictment and do not consider paragraph 15. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 3 of the indictment. Say by your verdict not guilty of the charged offense of injury to a child in count 3, and next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 3 as instructed in paragraph 15. 15. Count 3, lesser included offense. Now if you believe from the evidence beyond a reasonable doubt that on or about the 21st day of January 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did recklessly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with the hand of Jose Ruiz, and you find beyond a reasonable doubt that the defense of reasonable emergency medical care as instructed in paragraph 10 does not apply, then you will find the defendant Jose Ruiz guilty of the lesser included offense of reckless injury to a child in count 3. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant Jose Ruiz not guilty of the lesser included offense of reckless injury to a child in count 3. Count 4. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 23rd day of January 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by pinching Mercedes Lozoya with the hand of Jose Ruiz, then you will find the defendant Jose Ruiz guilty of the offense of injury to a child as charged in count 4 of the indictment and not consider paragraph 17. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 4 of the indictment. Say by your verdict not guilty of the charged offense of injury to a child in count 4, and next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 4 as instructed in paragraph 17. 17. Count 4, lesser included offense. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 23rd day of January 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did recklessly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by pinching Mercedes Lozoya with the hand of Jose Ruiz, then you will find the defendant Jose Ruiz guilty of the lesser included offense of reckless injury to a child in count 4. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant Jose Ruiz not guilty of the lesser included offense of reckless injury to a child in count 4. 18. Count 5. Now, if you believe from the evidence beyond a reasonable doubt that on or about the first day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by inserting tacks into the feet of Mercedes Lozoya, then you will find the defendant Jose Ruiz guilty of the offense of injury to a child as charged in count 5 of the indictment and do not consider paragraph 19. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 5 of the indictment. Say by your verdict not guilty of the charged offense of injury to a child in count 5, and next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 5 as instructed in paragraph 19. 19. Count 5, lesser included offense. Now, if you believe from the evidence beyond a reasonable doubt that on or about the first day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did recklessly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by inserting tacks into the feet of Mercedes Lozoya, then you will find the defendant, Jose Ruiz, guilty of the lesser included offense of reckless injury to a child in count 5. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Jose Ruiz, not guilty of the lesser included offense of reckless injury to a child in count 5. 20, count 6. Now, if you believe from the evidence beyond a reasonable doubt that on or about the second day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with a belt, then you will find the defendant, Jose Ruiz, guilty of the offense of injury to a child as charged in count 6 of the indictment, and do not consider paragraph 21. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 6 of the indictment. Say by your verdict not guilty of the charged offense of injury to a child in count 6, and next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 6 as instructed in paragraph 21. 21. Count 6. Lesser included offense. Now, if you believe from the evidence beyond a reasonable doubt that on or about the second day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with a belt, then you will find the defendant, Jose Ruiz, guilty of the lesser included offense of reckless injury to a child in count 6. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Jose Ruiz, not guilty of the lesser included offense of reckless injury to a child in count 6. Count 22. Number 22, count 7. Now, if you believe from the evidence beyond a reasonable doubt that on or about the third day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by pulling the hair of Mercedes Lozoya with the hand of Jose Ruiz, then you will find the defendant, Jose Ruiz, guilty of the offense of injury to a child as charged in count 7 of the indictment, and do not consider paragraph 23. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 7 of the indictment. Say by your verdict not guilty of the charged offense of injury to a child in count 7, and next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 7 as instructed in paragraph 23. 23. Count 7. Lesser included offense. Now, if you believe from the evidence beyond a reasonable doubt that on or about the third day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by pulling the hair of Mercedes Lozoya with the hand of Jose Ruiz, then you will find the defendant, Jose Ruiz, guilty of the lesser included offense of reckless injury to a child in count 7. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Jose Ruiz, not guilty of the lesser included offense of reckless injury to a child in count 7. Number 24, count 8. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 5th day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with a cell phone, then you will find the defendant Jose Ruiz guilty of the offense of injury to a child as charged in count 8 of the indictment and do not consider paragraph 25. If you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of injury to a child as charged in count 8 of the indictment, say by your verdict not guilty of the charged offense of injury to a child in count 8, and next consider whether the defendant is guilty of the lesser included offense of reckless injury to a child under count 8 as instructed in paragraph 25. 25, count 8, lesser included offense. Now, if you believe from the evidence beyond a reasonable doubt that on or about the 5th day of February 2022 in Bexar County, Texas, the defendant, Jose Ruiz, either acting alone or together as a party with Katrina Mendoza, did intentionally or knowingly by act cause bodily injury to Mercedes Lozoya, a child who was 14 years of age or younger, by striking Mercedes Lozoya with a cell phone, then you will find the defendant, Jose Ruiz, guilty of the lesser included offense of reckless injury to a child in count 8. If you do not so believe, or if you have a reasonable doubt thereof, you will find the defendant, Jose Ruiz, not guilty of the lesser included offense of reckless injury to a child in count 8. You are instructed that your verdict in each count must be unanimous. If there is evidence presented of more than one alleged instance that could constitute an offense committed by the defendant against the complainant, if any, you are instructed that your verdict on each count must be unanimous about which specific instance, if any, constituted the commission of the offense in each of the individual counts. Evidence of any other alleged acts of misconduct by the defendant against the complainant in this case is not to be considered unless you believe those acts, if any, were committed beyond a reasonable doubt. With regard to those other acts, if any, you are instructed that said evidence was admitted, if it was, only for the purpose of showing the state of mind of the defendant and the complainant and the previous and subsequent relationship between the defendant and the complainant, if it does, and for no other purpose. You are instructed that under our law, that no evidence obtained by an officer or other person in violation of any provision of the Constitution or laws of the state of Texas or the Constitution or laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. Therefore, if you believe or have a reasonable doubt that the evidence was obtained in violation of any provisions of the Constitution or laws of the state of Texas or of the Constitution or laws of the United States of America, in such event, the jury shall disregard any such evidence so obtained. Our law provides a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you're instructed that you cannot and must not allude or refer to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service or any text or instant messaging service or any social media platform, internet chat room, blog or website to include, but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter or X, to communicate with anyone any information or receive any information from anyone about this case or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item, or evidence or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt. Gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty of the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your questions to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. Before we begin, can I have parties approach, please?
understanding, off the record in discussion with the defense, you decided to reserve your time for rebuttal?
Yes, that's correct, Judge.
All right, Ms. Conley, are you prepared to proceed?
Yes, Your Honor. Good afternoon. First of all, I apologize for the drama on Friday and for the minor drama on jury selection when I became disoriented. Did recover from that one, but Friday was a disaster, and I apologize for it. What I'm asking you to consider, first of all, what if Jose wasn't home that day? Would he be in that chair right now? I think it's an interesting point. Mercedes is dead. Mercedes, precious Mercedes Lasoya, 5-year-old child, is dead. How did she die? The state's not worried about that. They're just worried about what happened before she died. There are plenty of charges. I won't go into all of them. I don't want to drive you crazy. You've been here long enough. I am most deeply influenced by Jordan. She had a front row seat to everything that happened. Maybe she was asleep sometimes. Basically, she was there. I don't believe she had an opportunity to be coached. She gave her statement to a social worker apparently the day after her sister was found dead. And the testimony she gave was that her mother was jamming food into her sister's mouth. Her sister was spitting it out. She kept jamming it in. And ultimately, she shoved a spoon down Mercedes' throat. At that point, Mercedes fell on the floor, according to Jordan, and she had no more breath. Jordan said that her mom tried to put breath in Mercedes, but it didn't work. I believe she said it happened twice, but it didn't work. Mercedes had no more breath. My recollection is that Jordan then said, my mom took me and Mercedes and we went to her boyfriend's apartment somewhere in the complex. Mercedes had an opportunity to say, oh, Jose brought her back to life when we got to his place. She never said that. As far as she was concerned, her sister was dead when they left Jeanette's apartment. And they were in Jeanette's apartment. They weren't in Jose's apartment. Who was Jeanette? You never saw her. State never brought her. But she was there. She had been the place where Katrina had stayed with her children for 2 days before her death. Katrina told you that. Now, I'm telling you things that I saw, my perceptions, my beliefs. You are not required to listen to me. I'm required to tell you what I think and to hope you will go the direction that I'm trying to put you in. But you don't have to. You are the final determiner of what is truthful in what you've just seen for the past week. What did CPS, Child Protective Services, do to protect Mercedes? His name is not called Jose Protective Services. The name of the agency is Child Protective Services. Did you hear anything that indicated that they protected Mercedes? Anything at all? I would suggest to you that you didn't. You heard a very fine man, Mr. Adame, report on what he saw as an investigator, but you didn't hear any testimony about, well, we're CPS and we did this or that. To my knowledge, you didn't see it. Again, it's your information, it's your beliefs that count, not what any lawyer tells you. And then there's the police. We had, I believe, 3 neighbors that testified that they called the police because they heard a child crying in agony. Not just moaning and groaning because she didn't have a toy, but crying in pain. They heard they heard hits, they heard smacks. They called the police. With the witness Mo, as I recall, they didn't show up. with the other witness, the couple, the woman said they did come to the upstairs apartment, but they didn't go inside, to the best of her knowledge. They just stayed outside. I didn't hear any follow-up. It's up to you. Did you hear any follow-up by SAPD? Now, I'm not telling you that that cop should have broken in the door. In the present climate, he'd probably have been arrested if he had broken in the door. But he could have followed up with somebody from his department the next day looking into, was the child all right? You didn't hear any evidence whatsoever that anybody checked up on Mercedes. There was another time that that neighbor called, as I recall, and she said that there was no response at all. In both cases, that neighbor was not contacted apparently by anybody to follow up on the story about whether the child was safe or not. Ultimately, that's really what we're talking about in this whole case. Who protected the child? The state has submitted Katrina Mendoza, the co-defendant, as the witness against Jose. Technically, there are, in my opinion, only 3 people, that would have the information on what actually happened. Katrina, Jose, and Jordan. The judge has instructed you cannot rely completely on the testimony or evidence produced by the accomplice. And I ask you, what was produced, except what Jordan said, other than by the accomplice? I would say everything. Everything came in from her. Was she believable? That's your decision, not mine. She called her daughter a liar. She said Jordan didn't really see her shoving food down the child's mouth. Jordan didn't really see her put a spoon in her mouth. Jordan didn't really see her fall to the floor. And Jordan didn't really see her stop breathing. Jordan never used the word stop breathing. Again, what I'm saying to you is what I recall. I'm not trying to mislead you. Your statements, your thoughts and remembrance may be different than mine. It's you that count. I can't say that enough. She also said that reports from police and whatnot were wrong. An interesting thing I thought about Katrina's testimony was her memory that sometimes was crystal clear, and other times she couldn't remember anything.
And brought into homicide and has another conversation with Sergeant Gomez and Detective Powell, and she continues now to perpetuate her lies.
What time did you go to Detroit, Michigan on Monday? Monday morning? Okay. On Monday morning, what condition was Jamie in? She was okay. She was okay? Was she awake, asleep?
No, she wasn't sleeping.
She was sleeping when you left? Sorry. You went there on Monday at what time?
Maybe 7 or 8 a.m.
In the morning?
Yeah.
Okay. 7 or 8.
Like every evening, I don't remember exactly.
Early in the morning?
Yeah.
But when you left out, Jamie was sleeping in her playpen? Okay. So, you go to Michigan. What time did you arrive in Michigan?
You say through here?
¿A qué hora te llegaste a Michigan?
2 horas con 30 minutos. 2 hours and 30 minutes.
2 hours and 30 minutes? Okay. So you get there, when you arrive there, who do you meet up with?
Yo llegué a un hotel, pero yo trabajaba de Uber, así que yo no puse a trabajar directamente en Uber.
She stayed at a hotel and she right away started working at Uber.
Pero ya después fui a visitar a otras amistades alrededor.
She went to visit some friends around there.
Who
did you go visit?
Amistades.
Who? Give me a name.
David, that's the name.
David?
Yeah.
David? So you arrive in 2 hours later, you get a Where did you stay?
No me recuerdo bien la ciudad que estaba ni el hotel.
Okay, come on.
You está guiando to Detroit, Michigan. You don't know what city, you don't know what hotel. You gotta come out with something better than that. No, okay? Pero el hotel de donde él se estaba hospedando, no. Super Day. Where you were staying, not David. Where you were staying. We're not talking about David. Super Day. That's it.
Super 8? Yeah. All right, so you arrived here 2 hours later. You said it's Super 8. You mentioned something about Uber.
Yo estaba trabajando en Uber, sí. She was working Uber. Why would you go, hold on. Why would you go work Uber in Detroit, Michigan, instead of doing it here in Cleveland, where your daughter is?
Yo también trabajaba aquí en Uber, aquí en Cleveland.
Okay, well, why go over there and not do it here? Why not do it here? Your daughter's here.
Porque me iba a ver a mis padres también en Michigan, entonces aproveché.
Friends over there in Michigan, so she took advantage of the fact that she was over there to visit me once she worked over there.
Pero no era siempre que lo hacía.
But not always. That's not, she didn't do that always.
And I'll take this to one way. At what point did you think that it would make sense to leave her here while you was in Detroit?
Él dice que no coja la manera mal, pero ¿en qué momento tú pensaste que está bien
por pasear, por
to travel,
por pasear,
Why not travel with you?
¿Por qué no llegaste a ir contigo?
porque yo pensaba regresar el viernes y ya quedarme con ella, o sea, era algo rápido, eventual, que no.
She said that because she had planned on returning on Friday and spending time with them, so
Porque no me iba a quedar en la casa de nadie.
she wasn't going to stay in anybody's house.
But why not bring her with you if you already knew that she had a condition going on at the time?
Si tú sabías que ella ya tenía una condición, estaba enfermita,
She needed
¿por qué no llevarla contigo?
Porque por eso mismo, por yo pasear, por
She wanted to have a good time and travel.
And this is the second interview that she had.
Cash in your wallet to purchase the second. But you took out money from the ATM machine. That's what you used.
Siempre la uso
All
para
right, so let's just start. We're gonna wrap up some stuff here. Okay, so you were at your house in June 16th. Okay, the day we were there. You woke up at 7:20 in the morning, right?
Él me estaba diciendo acerca de que tiene todo mi seguimiento. Él me dijo hace un momento en inglés que tengo mi seguimiento de donde yo me movilicé y todo eso.
Yeah, we have you on video. We have you on video. Your car coming home at 7:36 in the morning. What time are we going to see you leaving your house and when? What's the video going to show us? When we look at this video some more.
Okay.
Cuando nosotros empezamos a ver el video, okay, ¿qué ese video nos va a enseñar a nosotros? ¿A qué hora tú saliste de tu casa y cuándo? Nos está enseñando tú regresando a las 7:36 de la mañana. Pero a qué hora tú te fuiste. ¿Y qué día? Piénsalo bien, porque tu video, el video no miente. Okay? I'm telling you, think about it really good because the video does not lie. What is the video going to show us? Is the video going to show us that you left your house on Friday? Because it's showing you coming back, but when is it showing you leaving? Because we're going to look at the video and it's going to show us and it's not going to lie. Think about your answer. Think about your answer. This is la oportunidad tuya para decirnos la verdad, porque nosotros vamos a ver el video.
Sí,
y si no nos está diciendo la verdad, lo vamos a ver. Y vamos a ver que tú no estás mintiendo.
Sí, y él me está diciendo que va a haber más problemas al respecto.
Va a empezar los problemas.
So, Your Honor, with regards to Jaylene Candelario, she died a very awful death for being 16 months old. Dr. Elizabeth Mooney from the medical examiner's office is here and would like to make a statement. She was the medical examiner that did the autopsy, and the state of Ohio is going to provide you the autopsy and autopsy photographs to make this part of the sentencing record. Dr. Mooney?
For the record, we'll call this
State's Exhibit
State's
1.
Exhibit 1.
Good morning.
Hi, Doctor. For the record, can you say your name and spell it for the court reporter?
Yes, my name is Dr. Elizabeth Mooney, and it's spelled Mooney. I am currently employed by Cuyahoga County Medical Examiner's Office as a forensic pathologist and deputy medical examiner. In this capacity, I was assigned the task of performing an autopsy on little girl Jalen Candelario in order to determine her cause and manner of death. Unfortunately, this is one of the most tragic and unfortunate cases I've had in my career thus far. So today I speak on behalf of her and her findings with the course of my examination. We received Jalen at the medical examiner's office from the scene of her residence, at which time she was clothed in non-soiled clothing, indicating her body had likely been dressed prior to first responders' arrival, as they had mentioned before. So at autopsy, I examined the body of a very emaciated female toddler. At this point, she weighed 13 pounds. Upon review of medical records, this indicated approximately a 7-pound weight loss since her previous doctor's visit less than 2 months prior to that. The eyes were sunken, and she had temporal wasting in her face. In addition to that, the skin showed markedly decreased turgor, meaning when I pinch the skin, it remains in that tented position, indicating severe dehydration. In addition, there was abundant fecal material present, caked on the fingers, the fingernails, the hands, the feet, as well as the soles of the feet. The same material was found on her lips, which were very dry and flaking, as well as in her oral cavity, caked to her teeth. She did have some diaper rash appearance, as well as fecal material adherent to those areas. Of note, the body was essentially free of significant injury, with the exception of dried excoriations or scratches to the face region predominantly, and whether or not these were inflicted to herself in a conscious or semi-conscious state while she was dying, I'm unable to determine that. Very early decompositional changes were present. This included faint discoloration or green discoloration of the abdomen. These are typically changes that we see within 2 to 3 days following death. No additional changes to suggest that she passed away prior to this were found externally or internally. Upon internal examination, I continued to find evidence consistent with starvation and dehydration. These included pale discoloration of the musculature, which was minimal. There was a decrease in intra-abdominal fat to the point of transparency as her body tried to feed upon itself for nutrients. Her stomach contents consisted of less than 2 milliliters of brown mucoid material. This is about equivalent to the distal part of my thumb, a very small amount. The rest of her bowel just contained patchy fecal material, but very minimal throughout. Her organs, including her liver, kidneys, and thymic gland, showed evidence of stress, specifically microscopically on exam. I found no additional evidence of significant natural disease going on or congenital abnormalities. Following my exam, I submitted body fluids for additional toxicology and chemistry testing, which further confirmed my gross findings that she had passed in a state of severe dehydration. Her kidneys had failed, and she was in a state of ketoacidosis, which leads to coma and eventually death. As such, I determined the cause of death to be just that, starvation and severe dehydration due to pediatric neglect. To come to the exact wording of the cause of death was based on my findings, but also the medical definitions, which I'd like to reiterate here. Dehydration, and specifically starvation, is a lengthy and continuous deprivation of food as to cause suffering or death. Pediatric neglect is the failure of a caregiver to meet adequately a child's basic needs including physical safety, protection, food, clothing, shelter, education, medical or dental care, and supervision. In other words, neglect for Jalen's basic needs from a caregiver resulted in her death. As such, I ruled this manner to be homicide. Most homicide deaths involve acts of violence inflicted from one person onto another, but this case involves a failure to act appropriately to support another who is dependent on them, falling into a homicidal manner. In the absence of more advanced decompositional changes, I believe that the pain and suffering she endured lasted not only hours, not days, but possibly even a week. This is a pain that comes from an extreme thirst and hunger. It also stems from an inherent terror of isolation or the lack of someone present to provide that. My knowledge on the depth of this suffering may not be as extensive as a medical or a mental health professional, but as a physician with psychiatric and pediatric training, I feel comfortable stating that the deprivation of food coupled with physical isolation and caregiver abandonment would be terrifying. We know that babies and children cry when they're hungry because it's unsettling and it's uncomfortable. That's almost immediately after birth. We also know that children as early as age 4 to 5 months experience separation anxiety, with the most extreme anxiety around 9 to 18 months. Jalen was 16 months old. This feeling of abandonment for days on end, coupled with the pain of starvation and extreme thirst, is a type of suffering I don't think any of us could ever fully fathom. So, as a forensic pathologist, it is said that we are the voice of the dead and given the responsibility to speak for those who can't. So this morning, I'm honored to maintain that mission. Thank you.
In addition, Your Honor, just so the record is very clear, the state of Ohio has tried repeatedly to contact Jalen's extended family, and absolutely no one has called the prosecutor's office, has returned a call from the prosecutor's office, has done nothing to acknowledge that Jalen was even part of their family. So if people come in this morning, it's going to be on the side of Crystal Candelaria, because on the part of Jalen, in addition to Dr. Mooney, who speaks for the dead through autopsy findings, Sergeant Teresa Gomez and Detective TJ Powell are going to speak to you. As you also look behind me, it is law enforcement, whether it be from Cleveland Homicide, from the FBI, from the district, from EMS. These are all the people that participated in this case, and that they are here to be the family for Jalen Candelario, because her own family did not have the courage to call the prosecutor's office and ask what was going on with their case. They were more concerned with their own daughter. TJ is going to, Sergeant is going to speak first. Do you want her to come to the podium?
Absolutely. Same thing, Sergeant. Just say your name and spell it for our court reporter so she can have an accurate spelling.
Teresa Gomez, Teresa Gomez. Good morning, Your Honor. Your Honor, thank you for allowing me to be the voice for Jalen Candelario, a beautiful angel whose life was cut short for no good reason. This tragedy should have never happened. I am Sergeant Gomez from the Homicide Unit. The entire Homicide Unit, Cleveland Homicide Initiative, and our partners from the FBI are here today in honor of baby Jalen Candelario. When we were first notified of this horrific case, we were all heartbroken. But when we started digging deeper into the investigation, it was beyond horrific. It was revealed that the defendant, Crystal Candelario, left her own child alone for hours, which led to days, which led to weeks. This 16-month-old baby was left alone in a pack and play to fend for herself for 11 days with no food, maybe milk, the clothing she had on, and the diaper she was wearing. This baby loved her mother, she needed her mother, and her mother betrayed her. Mothers usually want their children to have a long, happy life, but Candelaria placed more importance on a vacation in Puerto Rico with her boyfriend than the health, safety, and well-being of her own daughter. She chose to satisfy her own needs and desires over that of her own child. Jaylene's life ended because of her selfishness and disregard for Jaylene's precious life. Candelaria violated Jaylene yet again when she placed her little body in a clean outfit in order to orchestrate this facade that she was trying to portray for the investigators, either before or after she called 911. But Jaylene told us something different when we saw her eyes sunk in and wide open. We later learned that sunken eyes is a result of severe dehydration. To the naked eye, it appeared she had dirt in her mouth and fingernails. It wasn't until the next day that detectives learned that the dirt in fact was feces. Detectives also began to gain clarity as to what really happened to Jaylene. Candelaria's fabricated story, which she initially told detectives, began to unravel. There's no way things could have happened the way the defendant said they did, which left us with many unanswered questions. Detectives gained knowledge of the fact that Candelaria left Jaylene by herself for more than 10 days. Many hours of video surveillance revealed all of the comings and goings of Candelaria from June 5th through June 16th of 2023, when she discovered her daughter deceased. Investigators watched a total of 628 surveillance videos, which also included audio. On June 9th, audio surveillance captured the final time Jaylene is ever heard crying. Myself and the people sitting behind me, many who are mothers and fathers, are tormented by the thought of what Jaylene endured and what her last hours on earth were like. Any of us and thousands of others would have jumped at the opportunity to take care of this beautiful little girl. Jaylene died a long and agonizing death, afraid and alone, while her mother enjoyed the beach and sunshine. This is a case that myself, all the people behind me, and everyone around the world will have branded in our minds and in our hearts forever. Jaylene took her last breath, and our only hope is that Jaylene found herself in the arms of Jesus, feeling his warm embrace and love, something she did not receive from her mother. Jaylene, you will never be forgotten. Thank you, Your Honor.
And Detective Powell.
Same thing, Detective, if you don't mind, just please say and spell your first and last name.
Yes, Detective T.J. Powell, P-O-W-E-L-L, assigned to the Cleveland Police Homicide Unit. I was the lead detective investigator on this case, and I can honestly say, Your Honor, in my 17-year career as a Cleveland police officer, this by far is the most horrific case I've ever had to investigate. Now, I've been a detective for 10 years. First and foremost, I want to thank the entire homicide unit, the entire Cleveland Police Department, prosecutor's office. As you see, we're here, we're Jaylene's voice. Fortunately, there's no family on our side, but we're her family. I wrote a short poem, just something in commemoration of Jaylene's life. J is for the justice that'll be received today. A is for the angel wings she earned on that joyful day. I is for the incremental repetition, build-up of suspense for an innocent bystander's death that clearly makes no sense. L is for the lack of love while alone for 11 days. Y is for a young life that was taken away. N is for new eternal life Jaylene gained on that day. No child should ever have to die this way. Jaylen's life truly mattered. Unfortunately, she died trying to survive off of her own urine and fecal matter.
Lastly, Your Honor, you're going to hear that Ms. Candelaria was depressed. And no one more than I appreciate mental health and mental health issues and the programs that this court and my office have tried to implement to help folks with mental health. This is not the case here. This is not the case at all. Her actions speak louder than words. She had the wherewithal to leave Cuyahoga County and drive to Detroit, to be not with one man, but with two, let alone leaving a child, her own flesh and blood, in a pack and play. And during the time that she has been locked up, she has been making plans for the future, talking to other folks at other jails, other prisons. She had a conversation, which I find more disturbing than not, but on November 26, 2023, instead of wrought with emotion, wrought with guilt, crying about the death of her child, she's talking with a friend about her trip to Puerto Rico and what a blast it was and how much the car cost, and they got a truck versus a car even though it was more expensive, and they were concerned about the other woman that was on the trip because she liked to spend money, and they spent money on food. There was never mention about her daughter in her phone calls, and in fact, on January 6th of 2024, she's talking to her mother, who she repeatedly talks to, and they talk about God. God is forgiving, God is this. You also have to take responsibility for your actions. And God isn't in the courtroom. That's why we have judges, and that's why we have the law, because we have to follow the law. But this is what she says, because, you know, she wants to make us believe that she doesn't understand the English language. She goes on to say, there are people who have gone free here, killing people. I mean, imagine. I mean, intentionally, and mine was practically an accident. I mean, because it was not like I did it intentionally. It's not like I picked up a gun or a bat or the girl bled or something like that. That's it. It was practically the same thing that happened to me a few days prior. I had the same thing happen to me days prior. And I mean that day that it happened, that same situation happened. Were you starved when you were in Puerto Rico, Miss Candelaria? Did you not have a glass of water to drink when your mouth was parched? It is really pretty pathetic, Your Honor, because, you know, we always stand before you and say that the purposes and principles of sentencing are to punish the offender and to protect the public. And, you know, in the sentencing memorandum, the defense says, well, she's not going to do it again. Well, no, she's not going to do it again because she's going to prison. But it's the fact that she did it in the beginning that sticks with us. You don't do that. She was a mother. She got a title that means something in this world. Animals take care of their infants better. The thought of this child dying every day while she's having fun. Humanity can't stomach that. And those are the actions that need to be punished. She abandoned her daughter and left her for dead. So, yeah, she didn't see blood. She didn't see the aftermath of a baseball bat. But what she did see were her eyes open, looking at her saying, "Why did you do this to me?" Thank you, Your Honor.
Thank you, Ms. Furley. Okay, we're going to turn now to the defense. Mr. Smith.
Thank you, Your Honor. May it please the court, everything that I'm about to get into here today, and my client agrees with me, is no justification for her actions. And what the prosecution said, actions matter, and these actions are narcissistic, selfish, abhorrent, absolutely worst parenting imaginable. She pled to aggravated murder. She pled to child endangering. So everything we're about to tell you is mitigation. Just to kind of give you an understanding of who this person is. So she came over from Ecuador 2016 with her grandmother. She was here for a few years. Her parents came over and they lived together. She had her first daughter, Amaya, while she was married. She subsequently got divorced, was a single mom raising Amaya. Met the father of Jaylene in Ecuador. They had a relationship that unfortunately turned violent. While she was pregnant with Jaylene, he became physical with her. She came back to Cleveland, never to see him again, gave birth to Jaylene. He was never involved in Jayleen's life. She had 2 daughters on her with the help of her parents. She was struggling emotionally, physically, trying to work, support these children. Fast forward to 2023. It's just overwhelming. She even tried to harm herself. Took 20 Motrin. Ended up in Metro. In early February of 23, after spending just a few days in her room alone, her mother went to check on her, asked her what was going on. Her whole side of her body was numb. Didn't know what was going on. They took her to Hillcrest Hospital. She was admitted there, and they were doing some evaluations for her migraine. She was complaining about headaches and weakness, facial drooping, thought it was possible stroke. They put her on IV Depakote, which is an anti-seizure, also used to treat manic disorder. And at the end of the day, after evaluations, she was clean, nothing wrong with her brain. They gave her oral Depakote and Effexor, 2 antidepressants, and sent her home. She was not very clear on what those were, but she was taking them supposedly as directed. And then she returned to Hillcrest Hospital again in March, and there was a note from the doctor saying that she should have had plenty of Effexor, but she's saying that she's out and she needs more, and she's coming back with these same problems. So they had her evaluated again, and they were saying that her anxiety and her stress was the trigger for these physical manifestations, to what was happening to her, for the loss of sensation in the side of her body, the numbness. And they prescribed her more Depakote, more Effexor, and also Atarax to help her sleep, because she wasn't sleeping. And this is in March of 2023. And, take the medications as prescribed. And then medications ran out. She wasn't feeling any better. They weren't working. She stopped. Not supposed to do that with these drugs, Your Honor. These are very serious mental health drugs. And you need to be tapered off of these medications, or there could be some side effects. Not only the side effects, but the actual underlying conditions that she may have had or been suffering from are also going unmedicated at this time. And then we get into her trip. And be honest, I'm not going through that again. That's the worst thing I've ever heard. And I commend the prosecution and detectives for their work. It was unimaginable, terrible, and I feel for all you guys having to do with that too, and her family as well. It's when the prosecution showed pictures of her on her trip. Pictures can be deceiving. Personally, for having myself suffer from depression and anxiety, you can't tell what a person's going through from a picture, what they're dealing with on the inside. And I'm thankful for the support that I had from my family, my friends, my doctors. She didn't have any of that. She was hiding it from herself, from her parents. Nobody knew what she was suffering from. Her doctors even thought it was migraines and possible strokes. And to be honest with you, when I first met her, Your Honor, after this happened in June, I met a person that was devoid of emotion. Just after hearing what had happened on the news, and then I get the call, she wants to meet with me, and I go talk to her. It was not what I expected. She had no emotion. She couldn't explain anything. I had no idea what I was talking to. But I'll tell you right now, this is not the same person. This person now is compliant on her medications. She's been taking them through the prison throughout the whole time that she's been in here. Again, there's no justification for her action when she was out there, what she was doing. She could have called somebody, she could have done this, yes, but when you're in that state, when you're off medication, mismanaging your thoughts, you're not thinking clearly, her body she had to get out, and she was having fun. If she was okay, in her mind, Jaylene was okay. Of course that's not the case. But I will point to when she did finally get home, and we heard that 911 call, she didn't want this to happen. You could hear that. Screaming, help me, my daughter's dying. Yes, because of your actions, because of what your choices were. And you took responsibility for that, but that call, that one tiny breach from whatever was going on in her head, that reality that her daughter was dying, she was calling for help, she didn't want that. And again, Your Honor, she took responsibility. She pled aggravated murder. She pled to child endangering. Nothing's going to bring Jaylene back. She knows that. So then, after the fact, in her state, she was telling detectives whatever. She thought she had another daughter. She had a Maya she had to think about. She had her parents. And then the prosecution saying that nobody's here on behalf of Jaylene. That's wrong. Her parents are here. They love that girl. They love Jaylene. Her mother loved Jaylene. She didn't deserve what happened to her. Nobody does. But they're here to talk on behalf of Jaylene as well. They loved her. So this time around, I'd like to call her parents up to sit.
Sure. And same thing, just please identify themselves and spell their first and last name. Do we need an interpreter?
Yes, sir.
Robert, are you okay?
Good morning.
I'm going to ask, would you like to go first then? Identify yourself.
Yo solo voy a hablar.
She's just going to
Yo
talk.
solo
Oh,
voy
he's
a
just here.
Oh, okay, got it.
No, Luis. Yo.
Can you please say your name?
¿Puedo indicar su nombre?
Katie Torres. ¿Mi nombre?
Katie Torres.
Can you spell it for the record, Robert?
Puede leer de K con K,
K.
K-A-T-Y, ¿cierto?
K-E-T-T-Y.
K-E-T-T. K-E-T-T-Y. ¿Y Torres con S o?
Con S.
Torres, T-O-R-R-E-S.
Okay. And present with her is her husband and his name?
¿Es su nombre, señor?
Tu nombre.
¿Cómo?
Tu nombre.
Clever Candelario. ¿Cómo?
Clever Candelario.
Clever Candelario.
Él no escucha bien. Él no escucha bien. Tiene un problema de audición.
This gentleman has a hearing problem.
Okay, that's fine.
Okay.
Okay, Clever con C.
Con K.
Con K.
K-L-E-B-R.
K-L-E-V-E-R. ¿Y el apellido?
Candelario, con C.
Candelario. Same as the accident.
You good? All right, good.
Okay. Bien, señor. Frase por frase.
Excelentísimos jueces de la Corte,
Honorable judge of the court.
con el corazón partido en 1000 pedazos,
With my heart ripped apart in 1,000 pieces,
pero desde el amor y sostenida por Dios,
but speaking from love and maintained by God,
estoy aquí para decirle al mundo
I am here to tell the world
que mi hija salió de un hogar
that my daughter came from a home
donde se creó una relación de humanismo,
where there was relations of humanism,
valores,
values,
creencias,
beliefs,
afectos,
emotions,
calidez,
warmth,
donde lo más importante era la familia.
where the most important thing was the family.
Cristel creció y se formó
Crystal grew up and was educated
en un ambiente sano junto a sus padres.
in a healthy environment together with her parents,
Protegida y amada.
protected and loved.
Realizó sus estudios en nuestro país natal, Ecuador.
She studied and was educated in our native country of Ecuador,
Escogiendo la misma profesión de su abuelo y sus padres.
and she chose the same profession as her fathers and her grandfather,
La docencia.
teaching.
Sus años de edad adulta fueron marcados
Her years as an adult were marked by
por problemas de salud física y sentimentales.
both physical and emotional problems
Que no siempre terminaron de la mejor manera.
that didn't always end up in the best way.
Su salud emocional se vio afectada en más de una ocasión.
Her emotional health was affected on more than one occasion.
Pero entre trabajo, responsabilidades y el día a día,
But between her work, her other responsibilities, and her day-to-day life,
en un ir y venir, no logró priorizar la importancia de un tratamiento continuo.
in the middle of all that, she never ended up prioritizing or appreciating the importance of continued treatment.
Por lo que la depresión y la ansiedad y el trastorno de neurosis de conversión fueron ganando terreno en su vida.
And because of all that, her depression, anxiety, her conversion neurosis disorder, all ended up consuming her.
Razón por la que siempre sufría desmayos y pérdida del conocimiento.
And as a result of this, she suffered fainting spells and also loss of consciousness.
Con esto no quiero victimizar ni justificar a nadie.
In saying this, I don't want to victimize or justify anyone.
Solo mirar el yo interior de quien hoy está aquí sentada y siendo juzgada.
I only want to give a glimpse of the interior person, the ego of someone who is seated here and who is being judged.
Señores, las enfermedades de salud mental no se reflejan en el rostro.
Ladies and gentlemen, the sickness, a mental health illness is not reflected
Ni
in
en una-
someone's face,
Ni en una foto.
and also not in a picture, in a photo.
Nacen y se quedan en el alma
It arises and remains in the soul.
Solo un tratamiento a tiempo y eficaz con ayuda de terapistas y médicos ayudan a mejorarlo.
And only timely and effective treatment by therapists and doctors can help to improve those conditions.
Mi hija no tenía calidad de vida
My daughter did not have a good quality of life
porque ella no podía pausar el trabajo.
because she couldn't stop working.
Nunca nadie imaginó que este sufrimiento terminaría en tragedia.
No one ever imagined that this suffering would culminate in a tragedy.
Y hoy aquí quiero decirle a Yailin
And here I'm
que eres
here-
nuestro ángel, Yailin.
I want to say here before Jaylene, our angel,
Tu recuerdo vive en nosotros.
that your memory lives within us.
Siempre te amaremos.
We will always love you.
Te acuné en mis brazos.
I held you in my arms.
Tus abuelos nunca te olvidarán.
Your grandparents will never forget you.
Perdóname, bebé,
Forgive me
por vivir la oscuridad del conocimiento
for being in the dark
que me imposibilitó ver la luz y poder ayudar a tu
and for being
madre.
in the darkness that prevented me from seeing the light to see what was going on with your mother.
Hija querida, cuánto te amo.
My beloved daughter, I love you so much.
Lamento y me arrepiento
I lament and I am
por no
so
haber
sorry
por no haber detectado lo que estabas viviendo.
for not having detected what you were going through.
No leí tu corazón.
I could not see what was in your heart.
No me percaté del caos
I didn't notice the chaos
por el que estabas atravesando.
that you were going through.
Lamento ahora, hija de mi vida, causarte este dolor.
I lament my darling daughter that I caused you this pain.
Señores de esta sala,
Your Honor,
pido misericordia,
I ask for mercy.
clemencia y compasión
I ask for mercy, for clemency, and for compassion
para un ser humano
for a human being
que ha librado una dura batalla en su vida.
that has waged a very difficult battle in her life.
Y ruego no satanizarla,
And I beg that you not
ni señalarla.
I beg that you not demonize her and point the finger at her.
¿Quién en esta vida no ha pecado contra Dios?
Who in this life has not sinned against God?
Que levanten la mano quienes no lo han hecho.
Anyone who hasn't, let them raise their hand.
Pero como creemos en un Dios de amor y de bondad,
But since we believe in a God of love and of goodness,
en un Dios de perdón,
and a God of forgiveness,
Él está aquí con nosotros.
He is here with us.
Hija, te amo.
My daughter, I
Aquí
love
estaré siempre para ti.
you. We're here always for
Te
you.
voy a esperar toda la vida.
I'm going to wait by the rest of my life for you.
Sí.
Thank you. Bien.
Un momento.
Señores excelentísimos jueces de la Corte,
Honorable judges of the court,
estoy aquí consternado por todo lo sucedido,
I am shocked by everything that happened,
dándole apoyo moral y espiritual a nuestra hija.
and I am giving moral and spiritual support
Señores
to our
jueces,
daughter Crystal.
pido compasión, comprensión, empatía, misericordia para un ser humano que ha tenido una etapa de su vida cargada de mucho estrés y preocupaciones.
Gentlemen judges,
Las enfermedades mentales
Gentlemen judges, I ask for compassion, understanding, empathy, and mercy for someone who is going through a stage of stress and mental and emotional illness and worries.
las enfermedades mentales y emocionales no avisan.
Mental and emotional illness does not give warning.
Cada persona es un mundo.
Each person is a world unto herself.
Y el mundo interior de mi hija
And the inner world of my
se
daughter
convulsionó.
was shaken.
Sin darnos cuenta,
Without our having realized it.
la depresión, la ansiedad,
Depression.
la envolvieron hasta hacerle perder el juicio y la razón.
Depression and anxiety consumed her to the point of depriving her of good judgment and reason.
Aquí está mi hija Cristel, que también tiene un motivo para seguir adelante.
Here's my daughter Crystal, who also has a motive to go forward with your help.
Con la ayuda de ustedes y esa razón,
With your help and with this motive,
se llama Amaya,
her name is Amaya.
que tiene 7 años
She is 7 years old,
y espera ver a su madre
and she hopes to
y
see,
abrazarla
and she hopes to see her mother and hug her very soon.
muy pronto.
Very soon.
Ruego a ustedes, imploro, perdón, suplico, comprensión.
I beg for your help, forgiveness, and understanding.
Hija querida, recuerda siempre
My beloved daughter, always remember
que nunca te olvidaremos.
that we will never forget Jaylene,
mi amada nietecita,
my beloved granddaughter,
que tuve en mis brazos,
who I held in
que
my
todos
arms,
los días tenía que yo amanecer cogiéndola a mi nieta,
that every
quien
day
extraño mucho,
we miss you very much,
profundamente.
very deeply.
Su imagen